Go ahead and start streaming. Wow, yeah, that's a stream for sure. That's a stream for sure. Let's see how loud the actual reading will be in comparison. I'm gonna turn me up a fair bit. Throwing on some gain. The actual reading comparison. I'm gonna turn me up a fair bit. Okay, how is that? Okay, we're getting up in there, but we're not clipping, which is good. Well, I'm turned up a fair bit. That means I can turn all this stuff up too. How is that? Okay, we're getting up in there, but we're not clipping, which is good. Well, I'm turned up a fair bit. That means I can turn all this stuff up too. Uh-oh, it's gonna start echoing. I apologize. That's terrible. That is not the title of this video. I certainly hope that's not how it's showing on YouTube. I edited it already. Let's see. I have now changed the stream title, which is good. I'm gonna turn Subnautica down a fair bit, definitely, so I can focus in on what matters more here. Master volume down even more. Let me hear our read aloud reading. How that is in comparison. Where is it? There we go. Go for it.
BCRA, federal law prohibits corporations.
Actually, I could turn Subnautica up a bit and I hadn't thought about this, but I probably need to let people know that I'm streaming this. Didn't really think about it, but okay. Let's do this. I have a Discord nowadays, which is nice. Oh, this is not it. Come on. Here for that link. I'm here for the link to my actual. I thought I remember where that is clearly. Copy the link. Thrown in some Discords. But I'm probably not going to be able to check chat like much at all anyway, but. I knew it. Yeah, I saw that coming. This is going to be the most boring intro to a stream ever because I'm still just setting stuff up for like 10 minutes. Okay. Alright, I've done enough of that. It is time to at least pretend to get started. Let me see, are we seeing stuff well? Oh yeah, I'm going to monitor stream one more time just to... I'm going to hear myself talking and listen to the reading at the same time, just so I can get a feeling for how everything's going to sound in the mix at the same time. Right, so go ahead and start reading.
corporations and unions
I'm
from
just
using
looking
their
at feeling
general
for how-
treasury funds to make independent expenditures for speech that is an electioneering
I'm
communication
talking.
or for speech
I'm
that expressly
reacting. Oh
advocates the
no!
election or
I'm
defeat of a
pretending.
candidate.
Noises. Okay.
Is an electioneering
I'm
communication
talking.
or for speech
I'm
that expressly
reacting. Oh
advocates
no!
the election or
I'm
defeat of a
pretending.
candidate.
Noises. Okay. Okay, that sounds good. I mean, it sounds good enough, right? Like, all I can really expect. Okay, let's go ahead and officially start. Welcome back, gamers, once again to the quiet part. In today's little live stream, the plan is to read this document here in the top right. This document is the Supreme Court opinion on the Supreme Court case connected to Citizens United versus the Federal Election Commission. This is one of the most important pieces of Supreme Court case law in my lifetime. Okay, so for anyone who was born like in the 90s moving on, this singular outcome, this Supreme Court ruling, is likely one of the most important and influential things in your lives' modern politics, right? Maybe not your life itself, but in your modern politics, it is going to be this Supreme Court case that has affected everything. If you want me to go over the absolute basic overview and introduction, this is a Supreme Court case that focused in on and cared really intensely about how money is allowed to influence elections. Okay, so like federal elections, obviously, because this is the Federal Election Commission that was involved in this. The Federal Election Commission is kind of like the Department of Education, except it's a group in a commission format instead of a department that oversees laws and rulings connected to elections that take place at the federal level. So, like, we're talking about democracy. Hey, Andrea. We're talking about democracy itself. So this was a Supreme Court case in which somebody, that being an organization, a nonprofit named Citizens United, wanted to release a hit piece on Hillary Clinton. Yes, on Hillary freaking Clinton. They wanted to release a 90-minute film to the public, and they wanted to pay cable TV and supposedly movie theaters, and they wanted to pay to distribute for free a movie that was attacking a political candidate, a federal candidate for office that was campaigning. And they wanted to release this around the time of the campaign. And they are a nonprofit organization. They are not an individual. And up until this Supreme Court decision, it was neither legal nor illegal. It was gray whether or not a corporation or a trade union or a nonprofit, which is a different type of corporation, it was legally gray whether or not a group like that was allowed to put money into political advertising or not. There are some aspects of the laws that said it was illegal. There are other aspects that kind of left it gray. There were other aspects that also left it legal. And so these people wanted to make sure that they could distribute their literal propaganda is what it was, right? Their campaign affiliated advertising against Hillary Clinton. They wanted to distribute this, and they were worried that the Federal Election Commission, per their existing case law, would yell at them, right? They would either fine them or criminalize them for doing this according to existing law at the time. So Citizens United went to a lower federal court, and they were like, hey, we are worried that you're going to criminalize us. And then the court at the time was like, yeah, we probably will. Don't publish this. And then eventually the Supreme Court realized that this was Supreme Court level, and they took over and oversaw the case moving forward. So at some point, Citizens United had lawyers on their side defending and creating these arguments that organizations and unions have as much of a right to the free speech that is creating propaganda as individuals, and they shouldn't be treated as separate. So ultimately, the outcome of this, and I'll spoil the end, is the outcome is that after this Supreme Court case, it became legal for corporations and businesses and billionaires to buy campaign advertisements publicly. Even though it's a matter of free speech, the ultimate argument became that businesses are people, corporations are people, even if they don't reflect the people that oversee them. Corporations are people, and even if corporations have hundreds of billions of dollars more than any individual ever possibly could, they have just as much of a right to advertise for or against a political opponent or ally as much as they want. And so, in essence, almost every single aspect and millimeter of corruption that the United States has faced in the past 20 years, really the past 15 years, every single bit of it came back to this Supreme Court decision that decided that dollars, wealth, is a form of free speech. And you're allowed to use that wealth to lobby and buy and construct advertisements for political representatives or candidates running for office. This is not an often talked about Supreme Court case outside of, like, you know, government majors and political science majors. This is not something that it seems a lot of average people are engaging with or learning about. And so obviously this is the quiet part. And my entire purpose is to try and learn things that it kind of feels like we aren't really supposed to. So this is most definitely one of those things where most people never learn about this, and most people definitely don't ever learn about it with the depth and to the degree that I am about to. So the purpose of this stream is to learn about the Supreme Court case, to understand the history, and then I'm going to actually be creating a video based on what I'm learning right now. But I wasn't going to make a stream out of reading this until I realized that it is over 180 pages of legal jargon. And there was a 0% chance of me sitting through that completely on my own. And with the established kind of joke stream format I created with the whole Project 2025 thing, I thought, why not do what I said I would, which would be to stream me reading this while playing a video game so you can see me reading it. Maybe you can learn something with me, and I can get something entertaining out of it that helps me not absolutely lose my mind while reading such terrible jargon. So that is the plan. We are reading the Supreme Court opinion, which is essentially what the Supreme Court puts out on paper after they've made their decision, to justify their decision and to make sense of other such things, right? This is the main document coming straight from the Supreme Court itself on their ruling, and they're talking about this case. So with that in mind, I'm going to start it momentarily. I'm also going to be playing this wonderful, incredible video game called Subnautica right here. It is going to be very hard to explain or allow you, a random viewer or streamer, not a viewer, but the person I'm streaming to, the people I'm streaming to, it is going to be very hard to explain what my current setup is, but essentially I have a laptop, and I have a lapel mic plugged into my laptop. I have a pair of heads-up display glasses that I am currently using to emulate 3 displays. So I can see my stream, the document, and OBS at the same time, and my video game. But I'm using one laptop and emulating 3 screens with a pair of heads-up display glasses while laying inside of the box truck tiny home that I live inside of. And I am currently streaming over this box truck tiny home's Wi-Fi. So that's a little complicated. And that's the reason I don't have a face cam, is because I'm just laying down in bed while I play this game and soon stream this document. But before that, I'm going to do a couple of things. I'm going to disappear audibly for a second, and then I will be back in a minute or two, and I will start playing and start reading. I expect this will take, I don't know, 4 hours. It's 200 pages. I can probably get through 50 pages an hour. So yeah, that's what I'm expecting. But I'm going to take a moment to take care of a couple of other things in real life, and then I'm going to start playing. But the issue is, every time I move from this spot, I have to declip my microphone, take off my headphones, take off my heads-up display glasses, and do 20 other things. Hopefully stream doesn't die while I do this. Okay, I am now returning, but I have to flip this microphone to my shirt. I have to now carefully grab the laptop with all this crap plugged into it. Oh my god. Okay, and now I have to put on my heads-up display glasses. Okay, and now I get to put on my headphones. This is so much work. Oh my god. I did not build this box truck tiny home to be a streaming machine, so this is a little sketchy. Alright, turning on my mouse. Uh-oh, I got Discord pulled up by accident. Okay. Alright, I think I have a number of things working correctly right now. I'm going to start the document. Everything will become apparent as you read. The issue is that this is really high-level writing. And it's super jargon heavy, and it's super case law heavy. It's almost like you have to be a freaking you have to be like a lawyer to understand half of this. But I'm gonna go ahead and start it. And yeah, we're just learning about this Supreme Court case by reading the justices' collective opinion itself. And that'll all tie into a future video I have on this topic of the Citizens United versus FEC Supreme Court case and its ruling and outcome. All right, let's get started.
October term, 2009.
There you go.
Syllabus. Note, where it is
Turn it down just a
feasible,
little
a
bit.
syllabus headnote will be released, as is being done in connection with this case.
All right, and
at the
now I
time
get to
the
start
opinion is
Subnautica.
issued.
Play video
The
game.
syllabus constitutes no part of the opinion of the court but has been prepared by the reporter of decisions for the convenience of the reader. See United States versus Detroit Timber and Lumber Company, 200 U.S. 321, 337.
I am loading up
Supreme
my
Court of the
previous
United States.
save of Subnautica from when I was streaming
Syllabus.
Project 2025.
Citizens United v.
I don't know.
Federal Election Commission.
It's not a speed run. I'm just playing.
Appeal from the
for fun.
United States District Court for the District of Columbia.
So it started out in the District Court for the District
Number
of Columbia, which is a lower
08205.
federal court, and then it got
Argued March
jurisdiction
24th,
under the Supreme
2009,
Court. So it kind of
re-argued
escalated
September
up to
9th,
there.
2009 and decided January 21st.
This all kind of started
2010.
in 2007 originally. So
As
this took
amended
like
by
3
Section
years of
203
going
of the
back and
Bipartisan
forth and
Campaign
being
Reform Act of
escalated by
2002,
Citizens United, which was a
BCRA. Federal
conservative
law prohibits corporations
nonprofit
and
group.
unions from using their general treasury funds to make independent expenditures for speech that is an electioneering communication or for speech that expressly advocates the election or defeat of a candidate. 2 U.S.C. Section 441b. An electioneering communication is any broadcast, cable, or
Okay, it looks like
satellite
you can
communication
still
that
see it
refers
reading
to a
in the
clearly
top right, which is
identified
good.
candidate for federal office and is made within 30 days of a primary election. Section
I
434
hate
F
to say this, but I might have to
and that
slow
is
this voice
publicly
down because
distributed.
it's
11
just
CFR
that complicated.
CFR Section 100.29 A2,
I'll
which in
start
the
slow,
case of
and
a
as I get
candidate
used
for
to
nomination for
reading it
president,
like this again,
means
I'm sure
that
I'll
the
speed up.
communication see and be received by 50,000 or more persons in a state where a primary election
Democracy
is being
itself.
held within 30 days. Section 100.29 B
Okay.
3 2. Corporations and unions may establish
Andrea,
a
let me know if
political
things are
action
working or not.
committee, PAC, for
Okay, this is a
express
little slow.
advocacy or electioneering
Let me get that out of your way.
communications purposes. 2 U.S.C.
I'm gonna set it back to
Section
normal.
441b B2. In
Where am I in the
McConnell
game right now?
v. Federal Election Comment 540 U.S. 93, 203 to 209. This court upheld limits on electioneering communications in a facial challenge, relying on the holding in Austin versus Michigan Chamber of Commerce 494 U.S. 652.
So yeah, this Supreme Court
that political
decision
speech may be banned based on
was
the
connected
speaker's
to a
corporate
lot
identity.
of prior decisions.
In January 2008,
going back into the
Appellant
earliest
Citizens
of the
United,
2000s.
a nonprofit corporation, released a documentary, Hereinafter Hillary, critical of then-Senator Hillary Clinton, a candidate for
Yes,
her
so
party's
it was
presidential
all about
nomination.
a conservative
Anticipating that it would
nonprofit
make Hillary
that
available
made a
on
movie
cable television
against
through
Hillary
video on demand
Clinton,
within 30 days of primary
and
elections.
they were worried
Citizens
that
United
because they
produced
are a
television
group
ads
and
to
not
run on broadcast.
individuals,
Citizens United v.
they would get
Federal
in trouble
Election
for
COMMN syllabus.
this. What they argued is
And
free
cable
speech,
television.
but it's just
Concerned
propaganda.
about possible
You're a
civil and criminal penalties for
multi-million-dollar
violating Section
advocacy group.
441b, it sought declaratory and injunctive relief, arguing that
So
1.
injunctive
Section
means
441B is
they
unconstitutional
needed
as applied to Hillary, and 2.
I'll pause
BCRA's
this real quick.
disclaimer,
I've had to research
disclosure,
so
and
much legal
reporting
crap. Injunctive relief means that the FEC, the Federal Election Commission, is a group that has, the capacity to make some rules. It drowns you out a little when you talk at the same time. Okay, I'm gonna turn it down then, a fair bit. Okay, I'm gonna turn it down way more then. Um, an injunction is essentially like a legal order saying that the FEC can or cannot criminalize Citizens United for publishing this. So essentially, there's a legal thing where you can essentially ask a court, like, hey, I'm not sure if the thing I'm about to do is legal. Can you tell me if it's going to be legal? And if it is legal, can you make sure to tell the police or whoever's in power to not, get me in trouble for this under your order? So that's what they were originally seeking with the lower court is, hey, we want to make sure and we want it in writing that we're not going to get in trouble for publishing this piece because it seems like it's in a legal gray area. But I don't actually think that's what they were after. I think they specifically wanted to expand their right to publish crap like this through billionaires and giant corporations. I think that was the real political motivation in making this into a whole Supreme Court case.
Reporting requirements, BCRA sections 201 and 311, were unconstitutional as applied to Hillary and the ads. The district court denied Citizens United a preliminary injunction and granted
The BRCA is the Bipartisan Campaign Reform Act, BCRA,
held,
which was like an early 2000s act that essentially said, hey, giant corporations and businesses can't do advertising like this for political people. It has to go through the politician's official group or political action committee.
pp. 5-20. Citizen United's narrower arguments that Hillary is not an electioneering communication covered by Section 441B because
it's definitely electioneering communication.
11 CFR Section 100.29.
No, it most certainly is. They were just trying to.
Section 441B may not be
These guys were desperate to not get in trouble, essentially.
V. Wisconsin Right to Life Incorporated, 551 U.S. 449 WRTL, which found Section 441B unconstitutional as applied to speech that was not express advocacy or its functional equivalent, ID, at 481, Opinion of Roberts, C.J., determining that a communication is the functional equivalent of express advocacy only if it is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate, ID. At 469 to 470, that Section 441B should be invalidated as applied to movies shown through video on demand because this delivery system has a lower risk of distorting the political process than do television ads, and that there should be an exception to Section 441B's ban for non-profit corporate
Citizens United tried desperately to make really stupid, tiny arguments that, like, hey, technically we're offering it through video on demand, so it's not the same thing as like a TV ad for a candidate. They just really wanted to get away with this. That's all they wanted. They just wanted to be able to publish this and use a corporate degree of money for campaign advertisement. I think an interesting comparison here is, for example, a little thingy, whatever. It kind of LeBron. I think so. This Supreme Court case, the ruling took place in 2010. It's kind of started all in 2007, and the Bipartisan Campaign Reform Act was like 2002. And if you go really far back into American history, we're really talking about everything since Watergate. We're talking about money and politics and how those two things touch each other, and what corruption means in the United States, especially as it pertains to democracy, the democratic process, and the process of electing representatives. I think the best way to think about this piece of case law is kind of like in other parts of the world, like the UK. I think it's the UK, but in certain parts of the world, it's like kind of illegal to advertise medicine. Like ads for medicine, like pharmaceutical medicines, medications, are like illegal because that's not a thing that should be happening with like a medical thing. You shouldn't be able to advertise one medicine over another. A medicine should be a thing that's overseen by a doctor. It's kind of weird and dystopian if you think about it, that like we completely allow our airwaves to be dominated by advertisements for medicines that should be a very clear and objective thing that is overseen by someone with medical expertise. It's not like a food or even a service. Like a medicine is a completely different category of thing. Um, I can't remember either, but I think similarly there might be rules in other countries where like you can't advertise medicine that involves children or other similar things where like advertisements that involve children in certain ways aren't allowed just for virtue of oh, I think it's stuff that targets children in like a really explicit way. It's like targeting children in a very dangerous way. Um, those in other parts of the world are very common sense and reasonable expectations. Um, whereas in the United States, right now after 2010, if you have money, you could absolutely dominate the airwaves and YouTube and Netflix. You can absolutely completely dominate the world if you have enough money with advertisements or against a political opponent. Doesn't matter that you're not an individual. It doesn't matter if you represent an individual. It doesn't matter that not everyone has as much money to independently advertise like that. If you have more money, you have more free speech. You have more of a right to access the market for accessing people's minds, um, and you can spend that money however you want. And I think a really, really, really salient example of this is the recent actions of Mr. Elon Musk in Wisconsin, because he genuinely, and I mean it, tried to buy a Supreme Court race, a state level Supreme Court race. He tried to buy it. I saw this incredible, insane, mind-boggling advertisement that was put together by his PAC, his political action committee, which I think is called like America First or something, or AmeriPAC or something like that. It's the one that he donates to most aggressively. Um, he was giving out $1 million checks to people who would sign his petition and say that they were registered to vote and this sort of thing, which is likely, probably, maybe definitely illegal, to do giveaways and fundraisers that are connected to the democratic process in that way. But his PAC, his political action committee, which is something that's kind of closely tied to this discussion of advertisement by corporations and groups as opposed to individuals, and the meaning of wealth and what it means for free speech and the equality of free speech, his PAC released a video where one of the people he gave $1 million was like, "Hi, I'm so and so. I signed the petition and I won $1 million." And behind her is a giant like sign that says, "Vote for so and so." Right? So this billionaire dude, this multi, century billionaire dude, this guy that has hundreds of billions of dollars, put together a political action committee, which then made an advertisement showing that he was giving away money to people to vote the way that he asked them to. Like that happened. And the fact that he didn't immediately end up in prison or get massively delegitimized is due in part to the outcome of the Supreme Court case, which ruled that people can use money that way. And it created a court precedent that sort of reinforces the logic that a business and that a person's money are an extension of them, and they too have the inalienable right to free speech. So if someone has more money, they have more free speech. Um, the consequences of this have been an unbelievable influx in my anecdotal experience of money into politics, especially regarding federal elections. And I will during my research, I'll find a real citation for that. But as far as I can tell, that is a thing that has happened just in my adult life as a Gen Z person. This may be the most important piece of Supreme Court ruling in my lifetime, because and I genuinely mean like the vast majority, kind of all of the corruption in modern American politics has something to do with the outcome of this Supreme Court case. Back to the game.
Corporation, 513 U.S. 374,
I don't even know what I'm doing in the game right now.
Throughout the litigation, Citizens United has asserted a claim that the FEC has violated its right to free speech, and 3, the parties cannot enter into a stipulation that prevents the court from considering remedies necessary to resolve a claim that has been preserved. Because Citizen United's narrower arguments are not sustainable, this court must, in an exercise of its judicial responsibility, consider Section 441B's facial validity. Any other course.
So 441B is a section of, I believe, the Bipartisan Campaign Reform Act, which is in the purview of the Federal Elections Commission. So the
Chilling
question
effect
is whether or
caused by
not is this
Section
law right? Is it
441B's corporate
constitutional?
expenditure ban. This conclusion is
So yeah,
further
it
supported by the
banned
following.
corporations
1.
from
The
putting money into
uncertainty caused by the
elections,
government's
into
litigating
election
position.
advertisements.
2. Substantial time would be required to clarify Section 441B's application on the points raised by the government's position in order to avoid any chilling effect caused by an improper interpretation. And 3. Because speech itself is of primary importance to the integrity of the election process, any speech arguably within the reach of rules created for regulating political speech is chilled. The regulatory scheme at issue may not be a prior restraint in the strict sense. However, given its complexity and the deference courts show to administrative determinations, a speaker wishing to avoid criminal liability threats and the heavy costs of defending against FEC enforcement must ask a governmental agency for prior permission to speak. The restrictions thus func. Tie-in is the equivalent of a prior restraint, giving the FEC power. Analogous to the type of government practices that the First Amendment was drawn to prohibit. The ongoing chill on speech makes it necessary to invoke the earlier precedents that a statute that chills speech can and must be invalidated where its facial invalidity has been demonstrated. pp. 12 to 20.
Okay, interesting. So they're saying
2. Austin is overruled, and thus provides no basis for allowing the government to limit corporate independent expenditure.
okay, so they are saying that if a law passively gets in the way of free speech, if a law makes it so you have to contact the government to validate that what you're posting is legal, that must not exist. So that means a previous court case has now been overruled, and this is all down to the crux that with them having left the gray area that they did, with the Supreme Court never having previously ruled on this topic, and instead ruled on previous things that were related but not directly, there cannot be anything that has a chilling effect or an effect that gets in the way of free speech. So they're going to say that the law needs to be reformed. First Amendment was drawn to prohibit. The ongoing chill on speech makes it necessary to invoke the earlier precedents that a statute that chills speech can and must be invalidated where its facial invalidity has been demonstrated. So essentially, Citizens United got in and made their argument because there was existing court precedent that said that the Supreme Court is obligated to fight suppression of free speech in all forms, if someone can argue that that suppression is happening. So they used the First Amendment to invalidate the First Amendment, in my personal opinion, by allowing the wealthiest of people to have more speech than other people. Wow. Okay.
Expenditures. Hence, Section 441B's restrictions on such expenditures are invalid and cannot be applied to Hillary. Given this conclusion, the part of McConnell that upheld BCRA
The
Section
Bipartisan Campaign
203's
Reform
extension of
Act.
Section 441B's restrictions on independent corporate expenditures is also overruled.
I am ultimately in this little stream just doing some research, and I'm streaming it while I do it. But it's nice for me to put some new learnings into practice. An independent expenditure is when a corporation, without influence from a political candidate, engages with politics. So a corporation, a union, a business, any group of people at large scale or individual, can independently expend money to advertise for the success or defeat of a political candidate. But they cannot be taking orders from the politician, and they cannot be putting the money directly into the politician either. It can't be a campaign donation. It is independently spending that money because it's your opinion that you like that candidate. The issue and the stupidest thing about this entire case so far, in my research, is that anyone ever thought that it would ever be the case that any of these businesses are truly not taking orders from the politicians. That is stupid as shit. That really bothers me. That anyone would think that that's not going to happen, that these people aren't going to covertly communicate and strategize, even through more implicit means, to make sure that they are coordinating and essentially one listening to the other. Ridiculous. It's not an independent expenditure. Definitely the politicians are communicating with these people and groups.
pp. 20 to 51.
I mean, good God, what is
Although the
Elon and
First
Trump right
Amendment
now, if not
provides that
exactly that
Congress shall
exact
make no
thing
law
happening?
abridging the freedom of speech, Section 441b's prohibition on corporate independent expenditures is an outright ban on speech, backed by criminal sanctions. It is a ban notwithstanding the fact that a PAC created by a corporation can still speak, for a PAC is a separate association from the corporation.
Oh
Because
my
speech
God.
is an essential mechanism of democracy, it is the means to hold officials accountable to the people. Political speech must prevail against laws that would suppress it by design or inadvertence. Laws burdening such speech are subject to strict scrutiny, which requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. WRTL 551 US at 464.
Okay, let's see how much
This
stuff I have
language
built.
provides a sufficient framework for protecting the interests in this case. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints or to distinguish among different speakers, which may be a means to control content. The government may also commit a constitutional wrong when by law it identifies certain Citizens United v. Federal Elections COMMN.
Oh, is this going to be like
Syllabus.
it's going to read that every time?
Preferred speakers. There is no basis for the proposition that, in the political speech context, the government may impose restrictions on certain disfavored speakers. Both history and logic lead to this conclusion.
So essentially they're saying
20 to
that
25.
a person's wealth and
B.
thereby
The
a
court has recognized
corporation's
that the
wealth,
First Amendment
being a
applies
collective,
to corporations, e.g.,
um,
First Nat Bank of Boston versus
it
Bellotti,
shouldn't be discriminated
435 U.S.
upon.
765, 778, N14, and extended this protection to the context of political speech, see, e.g., NAACP button, 371 U.S. 415,
God, it's saying all these
428 to
laws is not fun.
429. Addressing challenges to the Federal Election Campaign Act of 1971, the Buckley Court upheld limits on direct contributions to candidates, 18 U.S.C. Section 608b, recognizing a governmental interest in preventing quid pro quo corruption. For 24
Quid
U.S.
pro quo
25
means
to 26.
one thing for
However,
another.
the court
Exchange is
invalidated Section
corruption. It's what you think of when you
608b
think of
as
corruption. Paying
expenditure
a
ban,
politician
which applied to individuals,
money, and then the
corporations,
politician
and
giving
unions,
a
because
person
it failed
benefits and
dead
power.
to serve any substantial governmental interest in stemming the reality or appearance of corruption in the electoral process, ID, at 47 to 48. While Buckley did not consider a separate ban on corporate and union independent expenditures found in Section 610, had that provision been challenged in Buckley's wake, it could not have been squared with the precedent's reasoning and analysis. The Buckley Court did not invoke the overbreadth doctrine to suggest that Section 608(e)'s expenditure ban would have been constitutional had it applied to corporations and unions but not individuals. Notwithstanding this precedent, Congress soon recodified Section 610's corporate and union expenditure ban at 2 U.S.C. Section 441b, the provision at issue. Less than 2 years after Buckley, Bellotti reaffirmed the First Amendment principle that the government lacks the power to restrict political speech based on the speaker's corporate identity. 435 U.S. at 784 to 785. Thus,
Yeah,
the
I
law
need to make
stood
a
until
prompt suit.
Austin upheld a corporate
That's what's
independent
next,
expenditure
I think.
restriction, bypassing Buckley and Bellotti by recognizing a new governmental interest in preventing the corrosive and distorting
What
effects
did
of
I just
immense
do?
aggregations of corporate wealth that have little or no correlation to the public's
Oops.
support for the corporation's political
Okay.
ideas. 494 U.S. at 660.pp. 25 to 32. C. This court is confronted with conflicting lines of precedent, a pre-Austin line forbidding speech restrictions based on the speaker's corporate identity and a post-Austin line permitting them.
Oh,
Neither
okay.
Austin's anti-distortion rationale nor the government's other
So
justifications
this is
support
the crux of what this document's going to get at too. The court is confronted with conflicting lines of precedent. A pre-Austin line, which is a different Supreme Court case precedent, forbidding speech restrictions based on the speaker's corporate identity, and then a post-Austin line of precedent permitting a discrimination based on corporate identity. Neither Austin's anti-distortion rationale nor the government's other justifications support the restrictions in this bill. All right, the First Amendment prohibits Congress from fining or jailing citizens or associations of citizens for engaging in political speech. But Austin's anti-distortion rationale would permit the government to ban political speech because the speaker is in association with a corporate form. Political speech is indispensable to decision making. Okay. Um, I think the First Amendment should be connected to human beings and not businesses, right? The ultimate moral discussion after this Supreme Court case is, are businesses people just because they're made up of people? And I think absolutely not. Businesses are not people. They are the centralization of power through a structure, a business or corporate structure. Um, Businesses do not deserve rights. And I mean human rights. They can have legal rights. I don't care that much. But when we talk about the original meaning of like an inalienable, and especially regarding the founding fathers' logic, which I don't agree with, but it's their logic, and it ends up being important for this discussion. The whole idea of like a God-given right, the God-given right of free speech, of the pursuit of happiness, all this sort of stuff. Their original logic was people matter, um, not businesses. But the First Amendment was written to make room for associations of citizens. But I don't think the founding fathers ever, in their lifetimes, ever imagined a world where corporations could become what they are now. True mega corporation monopolies. I don't think any of them could have ever even imagined that much power being allowed to be centralized the way that it is in the modern day. And that's considering the fact that like at that time period, people were slave owners with giant plantations and big charter businesses. There were wealthy, hugely influential people. But in my understanding of the founding fathers, they would have likened those people closer to monarchs than individuals. And the U.S. is not a big fan of monarchs, if you understand what I mean. But all right, I'm gonna keep it going. I've got hundreds of pages to go through, so I need to speed.
Support Section 441B's restrictions. pp. 32-47-1, the First Amendment prohibits Congress from fining or jailing citizens, or associations of citizens, for engaging in political speech, but Austin's anti-distortion rationale would permit the government to ban political speech because the speaker is in association with a corporate form. Political speech is indispensable to decision. Syllabus. Making in a democracy, and this is no less true because the speech comes from a corporation. Bellotti, Supra, at 777, footnote omitted. This protection is inconsistent with Austin's rationale, which is meant to prevent corporations from obtaining an unfair advantage in the political marketplace by using resources amassed in the economic marketplace. 494 U.S. at 659. First Amendment protections do not depend on the speaker's financial ability to engage in public discussion. Buckley, Supra, at 49. These conclusions were reaffirmed when the court invalidated a BCRA provision that increased the cap on contributions to one candidate if the opponent made certain expenditures from personal funds. Davis versus Federal Election Common, 554 U.S.
Oh God.
Distinguishing wealthy individuals from corporations based on the latter's special advantages of, e.g., limited liability, does not suffice to allow laws prohibiting speech. It is irrelevant for First Amendment purposes that corporate funds may have little or no correlation to the public's support for the corporation's political ideas. Austin, Supra, at 660. All speakers, including individuals and the media, use money amassed from the economic marketplace to fund their
See,
speech.
that's
and the
okay.
First
That's one of
Amendment
their
protects the
strong
resulting
arguments
speech.
is that they're saying that, well, everyone uses money for their speech in some form. I mean, if you're homeless, it's a lot harder to attend protests because you've got to be working, or that logic of like, everyone is engaging with the economic market, and ultimately, you know, having money for food, which you need for calories to then use your vocal cords and physically speak. That person's using their own funding. Why isn't money free speech? That's where they're starting to form their argument, and I think that's just kind of psychotic and anti-human. Deeply disconnected.
Under the anti-distortion rationale, Congress could also ban political speech of media corporations. Although currently exempt from Section 441B, they accumulate wealth with the help of their corporate form, may have aggregations of wealth, and may express views have, little or no correlation to the public's support for those views. Differential treatment of media corporations and other corporations cannot be squared with the First Amendment, and there is no support for the view that the amendment's original meaning would permit suppressing media corporations' political speech. Austin interferes with the open marketplace of ideas protected by the
Yeah,
First
they're
Amendment.
obsessed with the
New
open
York State
marketplace of
BD of
ideas.
Elections versus Lopez Torres.
Why does it got to be a
552
marketplace?
U.S.
Why does it have to be competition? Why
196,
does it have to be tied to the
208.
economics?
Its censorship is vast in its reach, suppressing the speech of both for-profit and non-profit, both small and large, corporations.
Yeah, so
pp.
a lot of people
32 to
argue the
40.
fact that like
2.
90
This
something
reasoning
percent of
also
all
shows the
corporations,
invalidity of the
make like
government's
less
other
than 5
arguments.
million or $1 million. I
It
can't remember
reasons
what it
that
is.
corporate
But they're
political
small
speech can be
businesses,
banned
right?
to prevent
So,
corruption
why
or its
can't those small
appearance.
businesses
The
do
Buckley Court found this
the
rationale
lobbying and the
sufficiently
advertising?
important to allow contribution
The
limits,
hilarious
but
thing is that
refused to
15 years
extend that
since then,
reasoning to
it's not
expenditure
the small
limits,
businesses that are doing
424
any of the
US
speaking.
at 25,
It is
and the
only
court
the
does
top
not do so
1%
here.
that are doing it.
While a single Belotti footnote purported to leave the question open, 435 U.S. at 788 N 26, this court now concludes that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption.
Yeah, this is something
That
I heard them
speakers may
say
have
earlier,
influence.
is that this court, let me see. This court now concludes that independent expenditures, so the utilization of money by corporations to independently involve themselves with politics. They don't give the money to the politician, but instead they use it for their own purposes, like advertisement. Um, this court now concludes that those kinds of independent expenditures, including those made by corporations, they're saying this. They're saying they don't believe they give rise to corruption, or even the appearance of corruption. That is the stupidest shit I have ever heard from a group of people that are all supposed to be the best lawyers in American history. How the fuck do you mean that what they mean is legally the appearance of corruption? They don't mean like, oh, what I'm talking about. They're using their own entire level of jargon and reasoning.
Influence over or access to elected officials does not mean that those officials. Citizens United v. Federal Elections COMMN. Syllabus. Are corrupt. And the appearance of influence or access will not cause the electorate to lose faith in this democracy. Caperton versus A.T. Massey Coal Company.
Oh, did they just say that? What? Even
distinguished.
even if it is corrupt,
pp.
I believe
40
in
to
the
45.
institution so hard that I'm okay with it being
3.
corrupt.
The government's asserted
The democracy will
interest in
sort itself
protecting
out. What?
shareholders from being compelled to
How's it
fund
going to sort
corporate
itself out
speech,
if it's
like
deeply
the
corrupt?
anti-distortion rationale, would allow the government to ban political speech even of media corporations. The statute is under-inclusive. It only protects a dissenting shareholder's interests in certain media for 30 or 60 days before an election when such interests would be implicated in any media at any time. It is also over-inclusive because it covers all corporations, including those with one shareholder. P46.4, because Section 441B is not limited to corporations or associations created in foreign countries or funded predominantly by foreign shareholders, it would be overbroad even if the court were to recognize a compelling governmental interest in limiting foreign influence over the nation's political process.
They're even saying
PP of 46 of 47,
that
D,
if a corporation has foreign investors, it's still okay for these people to influence politics through advertisement via independent expenditure.
Interests at stake, and whether the
What?
decision was well reasoned.
I'm so baffled
of abandoning Austin,
that anyone from any
the
political party would be like, yeah, it's a great idea. Unless that political party had direct ties to foreign organizations that were subverting the existence of America. Which, hey, that's its own entire thing.
Political speech is so ingrained in this country's culture that speakers find ways around campaign finance laws. Rapid changes in technology and the creative dynamic inherent in the concept of free expression counsel against upholding a law that restricts political speech in certain media or by certain speakers. In addition, no serious reliance issues are at stake. Thus, due consideration leads to the conclusion that Austin should be overruled. The court returns to the principle established in Buckley and Belotti that the government may not suppress political speech based on the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. pp. 47 to 50. 3. BCRA sections 201 and 311 are valid as applied to the ads for Hillary and to the movie itself. pp. 50 to 57. Disclaimer and disclosure requirements may burden the ability to speak, but they impose no ceiling on campaign-related activities, Buckley, for 24 U.S., at 64, or prevent anyone from speaking, McConnell, Supra, at 201. The Buckley court explained that disclosure can be justified by a governmental interest in providing the electorate with information about election-related spending sources. The McConnell court applied this interest in rejecting facial challenges to sections 201 and 311. 540 U.S. at 196. However, the court syllabus acknowledged that as-applied challenges would be available if a group could show a reasonable probability that disclosing its contributors' names would subject them to threats, harassment, or reprisals from either government officials or private parties. ID at 198.pp 50-52. The disclaimer and disclosure requirements are valid as applied to Citizens United's
So
ads.
there's a couple of things
They
connected
fall
to this.
within
It's not
BCRA's
just whether or not
electioneering
independent
communication
expenditures are
definition.
allowed
They referred to then Senator Clinton by name shortly before a primary and contained pejorative references to
the
her
Citizens
candidacy.
United is not just about
Section
whether or not
311
it's legal
disclaimers
for
provide information
corporations
to the
to
electorate, McConnell, Supra,
spend
at
money on elections.
196,
It's
and
also
ensure that
about
the
whether or
voters are
not if
fully
they do
informed
make
about who is
advertisements,
speaking,
should
Buckley,
they have to
Supra, at
disclose who is
76.
invested in them
At the
and
very
like
least,
who's doing
they
the
avoid
speaking at the
confusion by making
corporation
clear that the ads are not
and
funded
where the
by
money
a
came from.
candidate or political party.
So
Citizens United's
I don't remember
arguments
how
that
that's going to
Section
go out
311
or
is
how that goes down.
under-inclusive because it requires disclaimers for broadcast advertisements but not for print or internet advertising, and that Section 311 decreases the quantity and effectiveness of the group's
Yeah, there's
speech
some
for
really interesting
rejecting
stuff. Like, for
McConnell.
example, any
This
business,
court
no matter
also
how
rejects
big,
their
is allowed to
contention that
distribute
Section
writing
201's
and books
disclosure requirements
that
must be
directly
confined to
call
speech
for the
that
success or failure of a political candidate.
is the functional equivalent of express advocacy under
I don't even know how I
WRTL's
personally feel
test.
about that. Like,
For restrictions on
yes,
independent expenditures,
obviously,
551 U.S. at
but
469
also,
to
like,
476.
again, the
Opinion
issue
of
is
Roberts, C.J.
why should a corporation
Disclosure is
have
the
that
less
much power
restrictive alternative
to
to more
oversee this stuff?
comprehensive speech regulations. Such requirements have been upheld in Buckley and McConnell. Citizens United's argument that no informational interest justifies applying Section 201 to its ads is similar to the argument this court rejected with regard to disclaimers. Citizens United finally claims that disclosure requirements can chill donations by exposing donors to retaliation, but offers no evidence that its members faced the type of threats, harassment, or reprisals that might make Section 201 unconstitutional as applied.
Right, so they're arguing
pp. 52.
that, ooh, our people are going to get harassed if
55.
they find out what they're saying. Yeah, what the
For these
fuck
same
happened to the
reasons,
free market
this
of
court affirms
ideas?
the application
Let
of
them
the
fucking
Sections
find
201
out.
and
If they're fucking around,
311
let them find
disclaimer
out.
and
What is...
disclosure requirements
How can you ask for both? Like, the free market of
pp.
ideas, but also,
55
ooh,
to
I don't want to
56.
disclose who paid for this. You're going to
Reversed in
dislike
part,
me.
affirmed in part,
What?
and remanded. Kennedy, J., delivered the opinion of the court, in which Roberts, C.J., and Scalia and Alito, J.J., joined, in which Thomas,
These
J.,
are all
joined
different
as to all
names
but Part
of...
4, and in which Stevens, Ginsburg, Breyer, and Sotomayor, J.J., joined as to Part 4. Roberts, C.J., filed a concurring opinion, in which Alito, J., joined.
This is important. These are all different. The names of different Supreme Court justices themselves. Court affirms the application of this disclaimer and disclosure requirements. Reversed in part, affirmed in order, and remanded. These are all the names of the different people. Okay, this is really hard and complicated to explain, but essentially, when Supreme Court opinions get published, everyone gets to say that they support it or they dissent. Oh, concurring means agreeing. Concurring in part and dissenting in part. Yeah, so there's a group that agrees for it. Those are the yays, and then there are the nays. Those are the dissenting. So the court made a vote. I believe it was 5-4. But they did a vote where the majority said yes, we should let corporations invest in campaigns. Fuck that. But 4 people disagreed, so they get to write, I believe in here, who dissented versus who agreed. So Justice Kennedy delivered the opinion of the court. So the opinion of the court isn't like their collective agreement. It's, here's how we voted, here's where everyone stands, and here's their reasoning and logic. But they do at some point have to say, like, hey, collectively, this is the outcome of the vote and the argument for the outcome of the vote for whichever, group won the majority when they went to vote. So I'm going to go ahead and start this here. So I don't know what appellant means to this day. I'm pretty sure it just means the one doing the discussing with the court. It's not suing because this isn't really a lawsuit. It was an injunction. They were asking to know what was going to happen. I appeal for the United States District Court for the district. Yeah, this is January 21st. Okay, so now that was all just kind of like the intro. Now we are getting into sort of main part. Justice Kennedy was the one that delivered the opinion, which I don't know if that means he wrote it, if he organized it, I don't know. Or he spoke it or something, I don't know.
Justice Kennedy delivered the opinion of the court. Federal law prohibits corporations and unions from using their general treasury funds to make independent expenditures for speech defined as an electioneering communication or for speech expressly advocating the election or defeat of a candidate. 2 U.S.C. Section 441b. Limits on electioneering communications were upheld in McConnell v. Federal Election Common, 540 U.S. 93, 203-209, 2003. The holding of McConnell rested to a large extent on an earlier case, Austin v. Michigan Chamber of Commerce, 494 U.S. 652, 1990. Austin had held that political speech may be banned based on the speaker's corporate identity. In this case, we are asked to reconsider
Wow.
Austin and, in
Wow,
effect,
this first real
McConnell.
page explains a lot of things a lot better than some of the online resources I've been reading. So, at the original point, before this decision, federal law prohibited corporations from independent expenditures involved in electioneering communications. So that's election advertisement. Limits on communications were upheld in existing court precedents, one called McConnell versus Federal Election Committee, which is the Mitch McConnell, the one that looks like a fucking, he's already dead. He looks like he's been dead for years. The Mitch McConnell, Speaker of the House for the Republicans. I believe that's what he is. I don't remember. You might want to Google that. So he actually fought this once before in 2003. And then there was Austin versus Michigan Chamber of Commerce. Austin held that political speech may be banned based on a speaker's corporate identity. In this case, we are asked to consider Austin and, in effect, McConnell. It had been noted that Austin was a significant departure from ancient First Amendment principles. That actually sounds great. Businesses are not people.
McConnell. It has been noted that Austin was a significant departure from ancient First Amendment principles. Federal Election Common v. Wisconsin Right to Life Incorporated, 551 U.S. 449, 490, 2007, WRTL, Scalia, J., concurring in part and concurring in judgment. We agree with that conclusion and hold that stare decisis does not compel the continued acceptance of Austin. The govern. Citizens United v. Federal Election COMMN. Opinion of the court. Ment may regulate corporate political speech through disclaimer and disclosure requirements, but it may not suppress that speech altogether. We turn to the case now before us. IA. Citizens United is a non-profit corporation. It brought this action in the United States District Court for the District of Columbia. A three-judge court later convened to hear the cause. The resulting judgment gives rise to this appeal. Citizens United has an annual budget of about $12 million.
They were a $12 million business.
Most of its funds are from donations by individuals, but, in addition, it accepts a small portion of its funds from for-profit corporations.
Other big businesses.
In January 2008, Citizens United released a film entitled Hillary, the movie.
Wow, it's really giving you the full
We
breakdown.
refer
I
to
love
the
that.
film as Hillary.
Nice.
It is a 90-minute documentary about then-Senator Hillary Clinton,
Senator
who was
Hillary
a candidate
Clinton.
in the Democratic Party's 2008 presidential primary elections. Hillary mentions Senator Clinton by name and depicts interviews with political commentators and other persons, most of them quite critical of Senator Clinton. Hillary was released in theaters and on DVD, but Citizens United wanted to increase distribution by making it available through video on demand. Video on demand allows digital cable subscribers to select programming from various menus, including movies, television shows, sports, news, and music. The viewer can watch the program at any time and can elect to rewind or pause the program. In December 2007, a cable company offered, for a payment of $1.2 million, to make Hillary available on a video on demand channel called Elections 08. App 255A 257A. Some video-on-demand services require viewers to pay a small fee to view SA. Lect program, but here the proposal was to make Hillary available to viewers free of charge. To implement the proposal, Citizens United was prepared to pay for the video on demand, and to promote the film, it produced two 10-second ads and one 30-second ad for Hillary. Each ad includes a short, and, in our view, pejorative, statement about Senator Clinton, followed by the name of the movie and the movie's website address. ID, at 26A at 27A. Citizens United desired to promote the video on demand offering by running advertisements on broadcast and cable television. Before the Bipartisan Campaign Reform Act of 2002, BCRA, federal law prohibited, and still does prohibit, corporations and unions from using general treasury funds to make direct contributions to candidates or independent expenditures that expressly advocate the election or defeat of a candidate, through any form of media, in connection with certain qualified federal elections. 2. USC, Section 441B, 2000 edition, C. McConnell, Supra, at 204, and N. 87, Federal Election Com. v. Massachusetts Citizens for Life Incorporated, 479 U.S. 238, 249, 1986, MCFL. BCRA Section 203 amended Section 441B to prohibit any electioneering communication as well. 2 U.S.C. Section 441B, B2, 2006 edition. An electioneering communication is defined as any broadcast, cable, or satellite communication.
Yeah, this is literally before people could even comprehend the idea of something like TikTok.
Within 30 days of a primary or 60 days of a general election. Section 434.
Like, don't get me wrong, they tried to predict how things would evolve, but they couldn't even
FEC
imagine.
Regulations further define an electioneering communication as a communication that is publicly distributed. 11 CFR Section 100.29, A2, 2009. In the case of a candidate for nomination for president, publicly distributed means that the communication, see, and be received by 50,000 or more persons in a state where a primary. Citizens United v. Federal Elections COMMN opinion of the court. Election is being held within 30 days. Section 100.29, B, 3, 2. Corporations and unions are barred from using their general treasury funds for express advocacy or electioneering communications. They may establish, however, a separate segregated fund, known as a Political Action Committee, or PAC, for these purposes. 2. USC, Section 441B, B2. The monies received by the segregated fund are limited to donations from stockholders and employees of the corporation or, in the case of unions, members of the union. IBID. See, Citizens United wanted to make Hillary available through video on demand within 30 days of the 2008 primary elections. It feared, however, that both the film and the ads
that's
would be
where
covered by
Obama went
Section
on to win, right?
441B's ban on corporate-funded independent expenditures, thus subjecting the corporation to civil and criminal penalties.
So
under
this court
Sections
case was 2 years
437B.
into Obama's term,
In December
his
2007,
first term.
Citizens United sought declaratory and injunctive relief against the FEC. It argued that, 1. Section 441B is unconstitutional as applied to Hillary, and 2. BCRA's disclaimer and disclosure requirements, BCRA Sections 201 and 311, are unconstitutional as applied to Hillary and to the 3 ads for the movie. The district court denied Citizens United's motion for a preliminary injunction, 530F Sup 2D 274, DC 2008, per curiam, and then granted the FEC's motion for summary judgment, App 261A at 262A. CID, at 261A, based on the reasoning of our prior opinion, we find that the FEC is entitled to judgment as a matter of law. C. Citizen S. United v. FEC 530F Sup 2D 274 DDC 2008, denying Citizens United's request for a preliminary injunction. The court held that Section 441B was facially constitutional under McConnell, and that Section 441B was constitutional as applied to Hillary because it was susceptible of no other interpretation than to inform the opinion of the court. Electorate that Senator Clinton is unfit for office, that the United States would be a dangerous place in a President Hillary Clinton world, and that viewers should vote against her. 530F Sup 2D at 279. The court also rejected Citizens United's challenge to BCRA's disclaimer and disclosure requirements. It noted that the Supreme Court has written approvingly of disclosure provisions triggered by political speech even though the speech itself was constitutionally protected under the First Amendment. ID at 281. We noted probable jurisdiction. 555 U.S. ____, 2008. The case was re-argued in this court after the court asked the parties to file supplemental briefs addressing whether we should overrule either or both Austin and the part of McConnell which addresses the facial validity of 2 U.S.C. Section 441b. C 557 U.S. ____, 2009. 2. Before considering whether Austin should be overruled, we first address whether Citizens United's claim that Section 441b cannot be applied to Hillary may be resolved on other, narrower grounds. A Citizens United contends that Section 441b does not cover Hillary, as a matter of statutory interpretation, because the film does not qualify as an electioneering communication. Section 441b, B2. Citizens United raises this issue for the first time before us, but we consider the issue because it was addressed by the court below. LeBron vs. National Railroad Passenger Corporation, 513 U.S. 374, 379, 1995, C 530F Sup 2D, at 277, N6. Under the definition of electioneering communication, the video on demand showing of Hillary on cable television would have been a cable communication that read, to a clearly identified candidate for federal office, and that was made within 30. Citizens United v. Federal Elections COMMN opinion of the court. Days of a primary election. 2 U.S.C. Section 434, F3, A, I. Citizens United, however, argues that Hillary was not publicly distributed, because a single video-on-demand transmission is sent only to a requesting cable converter box and each separate transmission, in most instances, will be seen by just one household, not 50,000 or more persons. 11 CFR Section 100.29, A2, see Section 100.29, B3, 2. This argument
I'm
ignores
already
the
tired of hearing
regulations
it talk about
instruction on how to
numbers
determine whether a
for
cable
different
transmission, can be
laws and
received
code.
by 50,000 or more persons. Section 100.29, B3, 2. The regulation provides that the number of people who can receive a cable transmission is determined by the number of cable subscribers in the relevant area.
My God, and now they're getting into the
Sections
fucking
100.29, B,
fighting
7,
about
I,
like, oh,
G,
it was
2.
this many people,
Here,
so
Citizens United wanted to use a cable video
or it
on-demand
wasn't
system
enough
that had
people to count.
34.5
Like, they're
million
just
subscribers
desperate to be
nationwide.
allowed to use
App
a
256A.
$14 million company's
Thus,
money
Hillary could
for
have been received
an
by
election
50,000
advertisement.
persons or more. One Amici brief asks us,
How is that
alternatively,
legal?
to construe the
How?
condition that
I
the
don't.
communication and be received by 50,000 or more persons.
Why should that ever be
Section
legal? I just don't condone this.
2A, to require a plausible likelihood that the communication will be viewed by 50,000 or more potential voters, as opposed to requiring only that the communication is technologically capable of being seen by that many people. Brief for former officials of the American Civil Liberties Union as Amici Curiae 5. Whether the population and demographic statistics in a proposed viewing area consisted of 50,000 registered voters, but not infants, preteens, or otherwise electorally ineligible recipients, would be a required determination, subject to judicial challenge and review, in any case where the issue was in doubt. ID, at 6. In our view, the statute cannot be saved by limiting the reach of 2 U.S.C. Section 441b through this suggested interpretation. In addition to the costs and burdens of litigation, this result would require a calculation as to the number of people a particular communication is likely to reach, with opinion of the court. An inaccurate estimate potentially subjecting the speaker to criminal sanctions. The First Amendment does not permit laws that force speakers to retain a campaign finance attorney, conduct demographic marketing research, or seek declaratory rulings before discussing the most salient political issues of our day. Prolix laws chill speech for the same reason that vague laws chill speech. People of common intelligence must necessarily guess at the laws, meaning and differ as to its application. Connolly vs. General Construction Company, 269 U.S. 385, 391, 1926. The government may not render a ban on political speech constitutional by carving out a limited exemption through an amorphous regulatory interpretation. We must reject the approach suggested by the amici. Section 441B covers Hillary.
The government, meaning a different. Connolly versus General Construction Co. I don't know. They're listing a bunch of laws real quick. The government may not render a ban on political speech constitutional by carving out a limited exemption through amorphous regulatory. So again, there can be no hoops for free speech. And again, they're putting together then the idea of money being free speech, and being a corporation, a form of human identity that cannot be discriminated against. So you cannot say, oh, corporations can't do electioneering communications because it's so weird. This is anti-bureaucratic and it's anti-free speech if you believe that money is a human thing. If you believe that money and wealth are like necessarily human affects, like it's like a part of the human experience is money, down to like an etiological or what is the other word, I forget, but like a philosophical level. If you believe that a human is inseparable from their wealth, and that wealth is an extension of the human existence, then their logic makes sense. I just find it so insane that they would say these things aloud like this.
Hillary. The Citizens United next argues that Section 441B may not be applied to Hillary under the approach taken in WRTL. McConnell decided that Section 441B, B2's definition of an electioneering communication was facially constitutional insofar as it restricted speech that was the functional equivalent of express advocacy for or against a specific candidate. 540 U.S. at 206. WRTL then found an unconstitutional application of Section 441B where the speech was not express advocacy or its functional equivalent. 551 U.S. at 481, opinion of Roberts, C.J. As explained by the Chief Justice's controlling opinion in WRTL, the functional equivalent test is objective. A court should find that a communication is the functional equivalent of express advocacy only if it is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. ID at 469 to 470. Under this test, Hillary is equivalent to express advo. KC. The movie, in essence, is a feature-length negative.
Yep. Hey, that's a
Advertisement
reasonable
urges
thing they've
viewers
said.
to
At
vote
least I
against
know
the
they have
senator.
basic brains and they can be like, yeah,
Citizens United v. Federal
this whole
Election
movie was just a
COMMN.
shitting on Hillary thing, and it was.
Opinion of the court.
I don't know, it just was. Whether you
Clinton
like
for
her or not,
president.
like, that's what the video
In
was.
light of historical footage, interviews with persons critical of her, and voiceover narration, the film would be understood by most viewers as an extended criticism of Senator Clinton's character and her fitness
Yes,
for the
I
office
don't
of the
think it could be
presidency.
understood as anything except
The
that,
narrative may contain more
specifically.
suggestions and arguments than facts, but there is little doubt that the thesis of the film is that she is unfit for the presidency.
That is definitely the
The movie
thesis. Wow, I haven't
concentrates
heard the
on
word
alleged
thesis used in
wrongdoing
this
during the
context in a
Clinton
while.
administration, Senator Clinton's qualifications and fitness for office, and policies the commentators predict she would pursue if elected president. It calls Senator Clinton Machiavellian, APA 64A, and asks whether she is the most qualified to hit the ground running if elected president, ID, at 88A. The narrator reminds viewers that Americans have never been keen on dynasties and that a vote for Hillary is a vote to continue 20 years of a Bush or a Clinton era.
Wow.
White
You know what's
House
funny? I
ID
watched the
at
whole video, the whole
143A,
movie actually. It was an hour and a half, and I watched it on 2x speed.
Citizens United argues that Hillary is just a
It was just a
documentary film that
giant
examines certain
hit piece.
historical
It is
events.
not a
Read
documentary
Martelli
film.
35. We disagree.
Oh, that's hilarious. There's no
The
way.
movie's consistent emphasis
There's
is
no
on
way.
the relevance of these events to Senator Clinton's candidacy for president. The narrator begins by asking,
What a
could Senator
crazy
Clinton
reach.
become the first female president in the history of the United States? App 35A. and the narrator reiterates the movie's message in his closing line. Finally, before America decides on our next president, voters should need no reminders of what's at stake, the well-being and prosperity of our nation. ID at 144A or 145A. As the district court found, there is no reasonable interpretation of Hillary other than as an appeal to vote against Senator Clinton. Under the standard stated in McConnell and further elaborated in WRTL, the film qualifies as the functional equivalent of express advocacy.
Yes. Hey, at
Cite
least
as
they got far enough to
558
understand that, like, inarguably the
_____
movie itself was
2010
a
opinion
piece
the
of political
Corsi.
propaganda.
Citizens United further contends that Section 441B should be invalidated as applied to movies shown through video on demand, arguing that this delivery system has a lower risk of distorting the political process than do television ads. CF McConnell, Supra, at 207. On what we might call conventional television, advertising spots reach viewers who have chosen a channel or a program for reasons unrelated to the advertising. With video on demand, by contrast, the viewer selects a program after taking a series of affirmative steps, subscribing to cable, navigating through various menus, and selecting the program. See Reno vs. American Civil Liberties Union, 521 U.S. 844, 867, 1997. While some means of communication may be less effective than others at influencing the public in different contexts, any effort by the judiciary to decide which means of communications are to be preferred for the particular type of message and speaker would raise questions as to the court's own lawful authority. Substantial questions would arise if courts were to begin saying what means of speech should be preferred or disfavored. And in all events, those differentiations might soon prove to be irrelevant or outdated by technologies that are in rapid flux. See Turner Broadcasting System Incorporated v. at FCC, 512. UFES 622, 639, 1994. Courts, too, are bound by the First Amendment. We must decline to draw, and then redraw, constitutional lines based on the particular media or technology used to disseminate political speech from a particular speaker. It must be noted, moreover, that this undertaking would require substantial litigation over an extended time, all to interpret a law that beyond doubt discloses serious First Amendment
Interesting.
flaws.
So, I mean, I remember learning about the Supreme Court of the United States, the SCOTUS, that the Supreme Court says regarding itself that it is like exceptionally and extraordinarily neutral, right? Like they take the separation of powers, the what's the exact term? The three branches of governments and the checks and balances that exist between those three branches, and the separation of powers between those three branches of executive, judicial, and the other one. Executive, judicial? The hell am I forgetting? Congressional? Am I dumb? Executive implements the laws. Judicial determines whether or not laws they apply the laws to situations. Executive enforces them, and then I believe congressional, right? Three branches of government. It's congressional, right? Am I going crazy? Three branches, judicial. Oh, legislative. I'm so stupid. But that is kind of what Congress does. Congress oversees the making of laws. Um, so it's executive, judicial, and then legislative. I'm so stupid because they are the legislature. Either way, the Supreme Court's job, and like they really obsess over this, their job is to neutrally, like politically neutrally, thank you for saying that, Roya. Sorry, I didn't see it when you said it, but thank you for saying that. Yeah, legislative. I'm so stupid. Right, the Supreme Court always says that, like, ooh, we're elite, we're truly neutral. It is our job to not care about the politics at the time, and instead only to interpret the law without overstepping into the other branches. We do not enforce the laws. We do not write the laws. We just interpret them. They go really, 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 really hard into that all the goddamn time. And they do that a lot in this too, where they try to insist that they are politically neutral. But here they are saying it. We must decline to draw and then redraw constitutional lines based on the particular media or technology used to disseminate political speech from a particular speaker. I think that that is a bunch of 80-year-olds who have life terms not knowing that TikTok would be a thing. Like, I don't think they could have ever imagined that it's not AI, but machine learning would get so good that an application will come out that can automatically feed you incredibly and uncomfortably well-tailored dopamine hit spiking addictive content to your eyes using your patterns of behavior. I don't think they could have ever imagined such a dystopian sort of piece of technology happening, but it happened, and their refusal to reevaluate constitutionality in the face of continuing changes to communicative technologies, that is a stupid idea. I understand they want to be neutral, they don't want to have to flip-flop, but listen, it's not going to be long, and apparently it already does happen according to a lot of people, but it's not going to be long before a Elon Musk level corporation just floods TikTok with campaign advertisements. If that didn't technically already happen, if you look at what the right's done with essentially coercing and buying small social media influencers to reinforce things for them, like, I don't know, it just seems short-sighted to be like, ooh, we can't just go with the tech. You kind of do. The tech is much bigger than you thought it was.
The interpretive process
Much
itself
worse.
would create an inevitable, pervasive, and serious risk of chilling protected speech pending the drawing of fine distinctions. Citizens United v. Federal Elections COMMN opinion of the court. That, in the end, would themselves be questionable. First Amendment standards, however, must give the benefit of any doubt to protecting rather than stifling speech. WRTL 551 U.S. at 469, opinion of Roberts, C.J. Citing New York Times Company v. Sullivan, 376 U.S. 254, 269 to 270, 1964. D. Citizens United also asks us to carve out an exception to Section 441B's expenditure ban for non-profit corporate political speech funded overwhelmingly by individuals. As an alternative to reconsidering Austin, the government also seems to prefer this approach. This line of analysis, however, would be unavailing. In MCFL, the court found unconstitutional Section 441B's restrictions on corporate expenditures as applied to non-profit corporations that were formed for the sole purpose of promoting political ideas, did not engage in business activities, and did not accept contributions from for-profit corporations or labor unions.
Oh.
For 79 U.S. at 263 to 264, see also 11 CFR Section 114.10. BCRA's so-called Wellstone Amendment applied Section 441B's expenditure ban to all non-profit corporations. C2 U.S.C. Section 441B, C. 6 McConnell, 540 Section 114.
Oh god, it really struggles sometimes to say these things.
U.S. at 209. McConnell then interpreted the Wellstone Amendment to retain the MCFL exemption to Section 441B's expenditure prohibition. 540 U.S. at 211. Citizens United does not qualify for the MCFL exemption, however, since some funds used to
It
make the
needed to be
movie were
daytime. It's too
donations
dark
from
in the game right
for-profit
now.
corporations. The government suggests we could find BCRA's Wellstone Amendment unconstitutional, sever it from the statute, and hold that Citizens United's speech is exempt from Section 441B's ban under BCRA's Snow-Jeffords Amendment, Section 441B, C. 2. CTR of Oral Arg 37-38, September 9, 2009. The Snow-Jeffords Amendment operates as a backup provision that only takes effect if the Wellstone opinion of the court amendment is invalidated.
I am unironically having trouble separating the
concurring in judgment in
AI
part and
voice
dissenting in
in
part.
this document, which is the
The
same
Snow-Jeffords
as
Amendment would
the
exempt from Section
Project 2025 AI
441B's
voice that I
expenditure ban the
used.
political
It's not
speech of
AI.
certain
It's a
nonprofit
it
corporations
just
if
sounds
the
like it.
speech
It's
were
a
funded
text-to-speech,
exclusively
right?
by individual donors and the
I
funds were maintained in a segregated
am having
account.
trouble realizing that this
Section
is
441B,
technically
C.
like a
2.
different
Citizens
author
United would
than
not
Project
qualify for the
2025. My
Snow-Jeffords
brain wants to
exemption
imagine that
under
it's
its
still
terms as written,
the same
because
writers
Hillary was funded
because
in
I
part
listened
with
to it for
donations
30
from
hours.
for-profit
But I'm
corporations.
having to remind myself, these are Supreme Court justices. This is probably
Consequently, to
Justice
hold for
Robert, because he
Citizens
did like
United
half
on
of
this
this.
argument, The court would be
Um,
required to revise the text of
but it's so
MCFL,
hard because I
7
listened to it for
BCRA's
30
Rosling
hours with
Amendment,
this voice.
Section 441B, C6,
It would be
and
nice
ignore the
if you
plain
could
text
sort of
of
randomly
BCRA's
generate slight
Snow-Jeffords
differences in
Amendment,
the voices so
Section
you could
441B, C2.
kind
If
of
the court decided to create a de
psychologically tell
minimis
them
exception
apart
to
better as a
MCFL or
human.
the Snow-Jeffords Amendment, the result would be to allow for-profit corporate general treasury funds to be spent for independent expenditures that support candidates. There is no principled basis for doing this without rewriting Austin's holding that the government can restrict corporate independent expenditures for political speech. Though it is true that the court should construe statutes as necessary to avoid constitutional questions, the series of steps suggested would be difficult to take in view of the language of the statute. In addition to those difficulties, the government's suggestion is troubling for still another reason. The government does not say that it agrees with the interpretation it wants us to consider. See Supper Brief for Appellee 3, N1. Some courts have implied a de minimis exception, and appellant would appear to be covered by these decisions. Presumably, it would find textual difficulties in this approach too. The government, like any party, can make arguments in the alternative, but it ought to say if there is merit to an alternative proposal instead of merely suggesting it. This is especially Citizens United v. Federal Elections COMMN opinion of the court. True in the context of the First Amendment. As the government stated, this case would require a remand to apply a de minimis standard. TR of Oral Arg 39, September 9,
I think they usually say de
2009.
minimis, but it is
Applying this
trying its
standard would
best.
thus require case-by-case determinations. But archetypical political speech would be chilled in the meantime.
Ow, ow, ow.
First Amendment freedoms need breathing space to survive. WRTL
Give me a diamond?
Supra
No.
at 468 to 469.
I just need a
Opinion of
couple of
Roberts,
diamonds.
CEJ. Quoting NAACP button,
Just like I'm playing Minecraft again.
371 US 415, 433.
Oh wow, that's really scary. Look at this big guy over here. Huh. I'm
We
gonna go
decline
back in.
to adopt an interpretation that requires intricate case-by-case determinations to verify whether political speech is banned, especially if we are convinced that, in the end, this corporation has a constitutional right to speak on this subject. As the foregoing analysis confirms, the court cannot resolve this case on a narrower ground without chilling political speech, speech that is central to the meaning and purpose of the First Amendment. Seymour vs. Frederick, 551 U.S. 393, 403, 2007.
Guess I'll drop some of this stuff off.
It is not judicial restraint to accept an unsound, narrow argument just so the court can avoid another argument with broader implications. Indeed, a court would be remiss in performing its duties were it to accept an unsound principle merely to avoid the necessity of making a broader ruling.
Got plenty of lead. I
Here,
need
the lack of a
more
valid basis for an
lithium.
alternative ruling requires full consideration of the
Hey, lead, though.
continuing effect of the speech suppression upheld in Austin. Citizens United stipulated to dismissing Count 5 of its complaint, which raised a facial challenge to Section 441B, even though Count 3 raised an as-applied challenge. See Apply 23A, Count 3, as applied to Hillary, Section 441B, is unconstitutional under the First Amendment guarantees of free expression and association. The government argues that Citizens United waived its challenge to Austin by dismissing Count 5. We disagree. First, even if a party could somehow waive a facial challenge while preserving an as-applied challenge, that would not prevent the court from reconsidering Austin or addressing the facial validity of Section 441B in this case. Our practice permits review of an issue not pressed, below, so long as it has been passed upon. LeBron, 513.
LeBron!
U.S. at 379, quoting United States versus Williams, 504 U.S. 36, 41, 1992, first alteration in original. And here, the district court addressed Citizens United's
totally gonna drown.
challenge.
I'm cooked.
C530F Sup 2D at 278. Citizens wants us to enjoin the operation of BCRA Section 203 as a facially unconstitutional burden on the First Amendment right to freedom of speech. In rejecting the claim, it noted that it would have to overrule McConnell for Citizens United to prevail on its facial challenge and that, NLY the
Wow, I
Supreme Court
cannot
would overrule
find
its decisions. Ibid,
diamonds
Rodriguez
anywhere.
de Quijas v. Shearson / American Express Incorporated, 490 U.S. 477, 484, 1989. The district court did not provide much analysis regarding
that guy
the
looks pretty
facial
angry over
challenge
there.
because it could not ignore the controlling Supreme Court decisions in Austin or McConnell. Even so, the district court did pass upon the issue. LeBron, Supra, at 379. Furthermore, the district court's later opinion, which granted the FEC
The hell did
summary
I just
judgment,
hit?
was B, as on the reason. ING of its prior opinion, which included the discussion of the facial challenge. App 261A, citing 530F, Sup 2D 274. After the district court addressed the facial validity of the statute, Citizens
There's
United
another
raised
Reaper
its challenge
Leviathan
to
over there.
Austin
I'm
in this
probably
court.
going to hit it, and I'm probably just going
See
to have
brief
to
for
deal.
Appellant 30. Austin was wrongly decided
Because I am
and should
headed
be
directly
overruled.
for it.
ID at 30.
Uh-oh.
3.2. In these circumstances, it is necessary to
Oh my god, I
consider
see
Citizens
2
United's
right here. This
challenge
is
to
terrible.
Austin and the facial validity of Section 441B's
Get me out of here.
expenditure
This is
ban.
bad.
Second, throughout the litigation, Citizens United has asserted
Seems
a claim
important,
that the
though.
FEC has violated its First Amendment right to free speech.
Oh, I'm currently being attacked.
All concede
Huh.
that this.
Well,
Citizens
I'm just going to
United
try to not
v.
think about
Federal
that.
Elections COMMN opinion of the court. Claim is properly before us. And
Can you?
NCE a federal claim is
This guy will
properly
not leave me
presented.
alone,
A
huh?
party can make any argument in support of that claim. Parties are not limited to the precise arguments
Doesn't
they
mind
made below.
taking damage. Cool.
LeBron, Supra, at
LeBron!
379.
What? Oh my
E
god,
versus
I'm about to be
Escondido,
hit by 2 of these at the same
503
time,
US
aren't I? This is crazy.
519, 534, 1992, alteration in original.
Like, can you get off of me?
Citizens United's
Terrible.
argument that Austin should be overruled
Leave me
is not a
alone.
new claim.
Why are there 2 of you?
LeBron, 513
LeBron!
US, at 379.
Man, I really need to try to look up this actual court case. I don't know this one.
It is at most a new argument to support
Oh, this
what
is
has
like the
been
edge of the game, isn't it?
consistent claim that the FEC did not accord Citizens United the rights it was obliged to provide
I'm making
by
a
the
mistake.
First Amendment.
Yep. This is the ecological dead zone. I need to leave before
Third,
a
the
ghost
distinction
leviathan
between
comes and
facial and
murders me.
as-applied challenges
Oh,
is
look,
not
there
so
it
well
is.
defined that it has some automatic effect or that it must
Leave me
always control
alone.
the pleadings
Leave
and
me
disposition
alone.
in every case involving a constitutional challenge.
Wow, I'm really messing up the game
distinction
right
is
now.
both
Like, I'm bad.
instructive and necessary, for it goes to the breadth of the remedy
What is
employed by
going
the court,
on?
not what
I'm
must be
taking this
pleaded in
so
the complaint.
casually right now, too. Like,
See United States
I should be
versus
freaking
Treasury
out, but I
Employees,
just do not care.
513 U.S. 454.
What just happened?
477 of 478, 1995.
I
Contrasting
just got
the facial
attacked by
challenge with the
2
narrower remedy.
Reaper Leviathans and a
Parties
Ghost Leviathan.
cannot
Leave
enter
me
into a
alone!
stipulation
There's
that
2
prevents
of
the
you!
court from
Why?
considering certain remedies if those remedies
Dude, how
are
has my
necessary
ship
to
not
resolve a claim that has
exploded by
been
now?
preserved.
Look at this. It's not even
Citizens
getting
United
hurt.
has preserved its First
How?
Amendment challenge to Section 441B as applied to the facts of its case.
What?
And given all the circumstances, we cannot easily address
I
that
get it.
issue
You're
without
angry.
assuming
Leave
a
me
premise,
alone.
the permissibility of restricting corporate political speech that is itself in doubt. See Fallon.
Oh, I really
as
have
applied
pissed
and
off these things, huh? Wow, you were
facial
still under me?
challenges of
Wow,
third-party
okay. Well,
standing, 113
no, I'm
hard.
just gonna go up. I'm heading to the island.
L.Rev 1321, 1339,
Jesus Christ.
2000. NCEA cases brought, no general categorical line bars a court from making broader pronouncements of invalidity in properly as-applied cases.
Oh yeah, I'm way on the other
1327
side.
to 1328. As our request for
Leave me
supplemental
alone.
briefing implied, Citizens United's claim implicates the validity of Austin, which in turn implicates the facial opinion of the court. Validity of Section 441B. When the statute now at issue came before the court in McConnell, both the majority and the dissenting opinions considered the question of its facial validity. The holding and validity
Get
of Austin
off
were
of me.
essential
I'm
to the
trying to
reasoning of the
read.
McConnell majority opinion, which upheld BCRA's extension of
Leave me
Section
alone.
441B.
Get off!
C540 U.S. at 205.
Good God.
Voting Austin, 494 U.S. at 660. McConnell permitted federal felony punishment for speech by all corporations.
Oh my God,
including
leave me
nonprofit
alone.
ones, that speak on prohibited subjects.
Are you
shortly
stupid?
before
Go away.
federal elections. C540 U.S. at 203 to 209. For members
Dude, you're
of the
not
McConnell
getting me,
court would have
my guy.
overruled Austin, including Chief Justice Rehnquist,
I do not
who
care.
had joined the court's opinion in Austin but reconsidered that conclusion. C540 U.S. at 256 to 262, Scalia,
That seems
J,
like a nice little
concurring in
area. I'm
part,
heading down there.
concurring in judgment in part, and dissenting in part, ID, at 273 to 275, Thomas,
Leave me
J,
alone, you
concurring in
big
part,
red
concurring
fish.
in result in part, concurring in judgment in part, and dissenting in part, ID, at 322
Uh-oh.
to 338,
Oh God, they're going over who
opinion
agrees and
of
disagrees again.
Kennedy, J,
Oh, I
joined
finally
by
got it.
Rehnquist,
Finally
CJ,
registered as a
and
creature
Scalia,
attack.
J. That inquiry into the facial validity of the
Yeah,
statute
yeah,
was
now it's finally
facilitated
counting it
by
as
the
damage.
extensive
That took
record, which
forever.
was over
For no reason,
100,000
too.
pages long, made in the three-judge district court. McConnell v. Federal Election Common, 251.
Yeah, I
F.
get it.
Sup. 2D
Angry fish. The fish is
176,
angry with me.
209, DC 2003, per curiam, McConnell I.
But this, we're going to turn off
It is not the
the
case,
engine
then,
altogether.
that the court today is premature
Wow,
in
what an
interpreting
angry
Section
fish.
441B on the basis of a factually bare-bones
Yeah, I know.
record.
External hull
The
damage.
Washington State Grange versus
Just can't
Washington
go out
State
there
Republican
until
Party, 552 U.S.
it
442,
stops.
450, 2008, quoting Sabri versus United States, 541 U.S. 600, 609, 2004. The
Oh my god,
McConnell
there are
majority
two of them.
considered whether the statute was facially invalid. An as-applied challenge was brought in Wisconsin Right to Life Incorporated v. Federal Election Common, 546 U.S. 410, 411 to 412,
I gotta power down the engine.
2006, per curiam, and the court
And then I'm allowed to
confirmed
go
that the
clean it
challenge
up.
could be maintained. Then, in WRTL, the controlling opinion of the Citizens United v.
Wow.
Federal Election COMMN. Opinion of the court. Court not only entertained an as-applied challenge but also sustained it. 3 justices noted that they would continue to maintain the position that the record in McConnell demonstrated the invalidity of the act.
Yeah, I don't want to go to this side of it. That's where the fucking angry fish is.
At 485 to 504, opinion of Scalia, J.
I don't like it when
The
it's in the
controlling
darkness.
opinion
This
in
is unpleasant.
WRTL, which refrained from holding the statute invalid except as applied to the facts then before the court, was a careful attempt to accept the essential elements of the court's opinion
I'm totally
in
about to
McConnell,
get killed,
while
I can tell.
vindicating the First Amendment arguments made by the WRTL parties.
Oh my god, this is terrifying.
551 U.S. at 482, opinion of Roberts, C.J. As noted above, Citizens United's narrower arguments are not sustainable under a fair reading of the
Jesus,
statute.
this game gets scary at night.
In the exercise of its judicial responsibility, it is necessary then for the court
I
to
have an
consider
elite
the
strategy.
facial validity of
Go to
Section
sleep.
441B.
Problem solved.
Any other course of decision would prolong the substantial, nationwide chilling effect caused by Section 441B's
Chilling effect.
prohibitions on
Good
corporate
God.
expenditures. Consideration of the facial validity of Section 441B is further supported by the following reasons. First is the uncertainty caused by the litigating position of the government. As discussed above, see Part 2OD, Supra, the government suggests, as an alternative argument, that an as-applied challenge might have merit.
What? This isn't
This
even an
argument
actual
proceeds on the
cave.
premise that the non-profit corporation
I came
involved
here
here
for
may have
nothing.
received only de minimis donations from for-profit
So
corporations,
stupid. I'm
and
getting
that
out of
some
here.
non-profit corporations may be exempted
Fuck
from
you,
the
Warper.
operation
Leave me
of the
alone.
statute. The government also suggests that an as-applied challenge to Section 441B's ban on books may be successful, although it would defend Section 441B's ban as applied to almost every other form of media, including
Come on,
pamphlets.
both of you need to leave me alone right now. This is
CTR
ridiculous.
Revoral Arg 65 to 66.
That's how you know I
September
played
9,
this game like 20
2009.
times, because this shit would have
The
scared me
government
so bad
thus,
when I
by
started.
its own position, contributes to the uncertainty that
Keeper.
Section 441B causes. When the government, opinion of the court, holds out the possibility of ruling for Citizens United on a narrow ground yet refrains from adopting that position, the added uncertainty demonstrates the necessity to address the question of statutory validity. Second, substantial time would be required to bring clarity to the application of the statutory provision on these points in order to avoid any chilling effect caused by some improper interpretation. See Part 2C, Supra. It is well known that the public begins to concentrate on elections only in the weeks immediately before they are held. There are short timeframes in which speech can have influence. The need or relevance of the speech
I
will
really
often
disagree with
first
that.
be
That's
apparent at
fair.
this stage in the campaign. The decision to speak is made in the heat of political campaigns, when speakers react to messages conveyed by others. A speaker's ability to engage in political speech that could have a chance of persuading voters is stifled if the speaker must first commence a protracted lawsuit.
Yes,
By the time
okay,
the
so
lawsuit
I am
concludes,
making sense
the
of their
election will
argument.
be
They're
over
saying,
and the litigants in
oh,
most
if we
cases
leave
will
this
have neither the
gray,
incentive nor,
then
perhaps,
people have
the
to ask
resources
us
to
every
carry
time
on,
they
even
want
if they could.
to, people have to ask us every
Establish that
time
the
they
case
want
is not
to
moot because the issue
put
is
together
capable of repetition, yet evading
movies and
review.
advertisements.
WRTL,
So we need to
Supra,
just let
at 462,
all groups, no
opinion
matter
of
who,
Roberts,
no matter how
C.J.
wealthy, no matter how
Citing
big,
Los Angeles
everyone just
versus
needs to be allowed
Lennox,
to do it.
461 U.S.
I get the
95,
logic, but
109,
the consequences for
1983,
society,
Southern
what the
Pacific
hell?
Terminal Company v. ICC, 219 U.S. 498, 515, 1911. Here, Citizens United decided to litigate its case to the end. Today, Citizens United finally learns, 2 years after the fact, whether it could have spoken during the 2008 presidential primary long after the opportunity to persuade primary voters has passed.
So they're acknowledging that.
Third is the
Yes,
primary
something.
importance of speech itself to the integrity of the election process. As additional rules are created for regulating political speech, any speech arguably within their reach is chilled. See Part 2A, Supra. Campaign finance regulations now impose unique end. Citizens United v. Federal Elections COMMN. Opinion of the Court. Complex rules on 71 distinct entities.
Oh my
Brief
god,
for
I found
7
the
former
exit.
chairman of
That's not
FEC
good.
et al. As Amici Curiae 11 to 12. These entities are subject to
I
separate
don't know
rules
why.
for
I
33
don't know how to
different
find
types of
diamonds
political
anymore,
speech.
but I
ID
don't
at
know.
14 to 15 and 10. The FEC has adopted 568 pages of regulations, 1,278 pages of explanations and justifications for those regulations, and 1,771 advisory opinions since 1975. CID at 6 and 7. In fact, after this court in WRTL adopted an objective appeal to vote test for determining whether a communication was the functional equivalent of express advocacy, 551 U.S. at 470, opinion of Roberts, C.J., the FEC adopted a two-part, 11-factor balancing test to implement WRTL's ruling. See 11 CFR Section 114.15.
Oh, interesting. Had I not already
Brief
come
for
here?
Wyoming Liberty Group et al. As
I
Amici
didn't know that. I
Curiae
thought I already
17
did. I
to
was just gonna
27,
not
filed
in the
January
game.
15, 2009.
Well, I'm pretty sure I might be able to get
This
an eye on
regulatory scheme may
out of
not be a
this.
prior restraint
I'm gonna
on
do it.
speech in the strict sense of that term, for
Huh.
prospective speakers are not compelled by law to seek an advisory opinion from the FEC before the speech takes place. CF Near vs. Minnesota XREL. Olson, 283 UKES,
Music
697,
volume
712 to
down.
713,
Astro.
1931. As a practical matter, however, given the complexity of the regulations and the deference courts show to administrative determinations, a speaker who wants to avoid threats of criminal liability and the heavy costs of defending against FEC enforcement must ask a governmental agency for prior permission to speak. C2. USC Section 437F, 11 CFR Section
That's
112.1.
huge.
These onerous restrictions thus function as the equivalent of prior restraint by giving the FEC power analogous to licensing laws implemented in 16th and 17th century England, laws and governmental practices of the sort that the First Amendment was drawn to prohibit.
Oh, interesting
See
logic.
Thomas versus
Whoa,
Chicago.
whoa. Okay. This regulatory scheme. Prior restraint. For prospective speakers are not compelled by law to seek advisory opinion from the speech takes place. As a practical matter, however, given the complexity of the regulations, the deference court shows to administrative determinations, a speaker who wants to avoid threats of criminal liability and the heavy cost of defending against FEC enforcement must ask a governmental agency for prior permission to speak. Interesting. These onerous restrictions thus function as the equivalent of prior restraint by giving the FEC power analogous to licensing laws implemented in 16th and 17th century England. Laws and governmental practices of that sort that the First Amendment was drawn to prohibit. Now, so they're tying back to the real originations of the First Amendment, but again, what is up with this insistence that corporations and people are equatable? How did this false equivalency become so popular?
Park DIST, 534. US 316, 320, 2002, Lovell vs. City of Griffin, 303 US 444, 451 to 452, 1938, near Supra, at 713 to 714. Because the FEC's business is to censor, therein here's the danger that it may well be less responsive than a court part of an independent branch of government to the constitutionally protected interests in free expression. Friedman. V. Maryland, 380 U.S. 51, 57 to 58, 1965. when the FEC issues advisory opinions that prohibit speech, any persons, rather than undertake the considerable burden, and sometimes risk, of vindicating their rights through case-by-case litigation, will choose simply to abstain from protected speech, harming not only themselves but society as a whole, which is deprived of an uninhibited marketplace of ideas. Virginia versus Hicks, 539 U.S. 113, 119, 2003, citation omitted. Consequently, the censor's determination may in practice be final. Friedman, Supra, at 58. This is precisely what WRTL sought to avoid. WRTL said that First Amendment standards must eschew the open-ended rough and tumble of factors, which invite complex argument in a trial court and a virtually inevitable appeal. 551 U.S. at 469, opinion of Roberts, C.J. Quoting Jerome B. Grubart Incorporated v. Great Lakes Dredge and Dock Company, 513 U.S. 527, 547, 1995.
Is his name like CJ, or is he Chief Justice?
The FEC has created a regime that allows it to select what political speech is safe for public consumption by applying ambiguous tests. If parties want to avoid litigation and the possibility of civil and criminal penalties, they must either refrain from speaking or ask the FEC to issue an advisory opinion approving of the political speech in question. Government officials pore over each word of a text to see if, in their judgment, it accords with the 11-factor test they have promulgated.
Oh, they have an 11-factor test for determining it?
Intervention into the realm of speech. The ongoing chill upon speech that is beyond all doubt protected makes it necessary in this case to invoke the earlier precedents that a statute which chills speech can and must be invalidated where its facial invalidity has been demonstrated. See WRTL, Supra, at 482 to 483, Alito.
They're so obsessed with free speech as a concept that they've forgotten about the idea of propaganda.
J. Concurring, Thornhill versus Alabama, 310 U.S. 88,
or is this sort of like some sort of pearl clutching where it's like, well, I believe so deeply in the American people that they're not, that they are immune to propaganda. The American people are immune to propaganda.
Laws enacted to control or suppress speech may operate.
It's weird. Like, I'm a free speech absolutist too. I very aggressively.
Just a few examples of restrictions that have been attempted at different stages of the speech process. All laws
believe
found to be
in
invalid.
the underlying concept of free speech, even if I don't necessarily agree with it having to be tied to law, because law does not mean moral. But
Imposing a burden by impounding
I don't
proceeds
know.
on receipts.
All right, I'm gonna go get stabbed by this
Simon and
machine real
Schuster
quick. What's this?
Incorporated v. Members of N.Y. State Crime Victims BD 502 U.S.
Oh, the needle it
105,
uses is so scary because it looks fucking giant.
1991, seeking to exact a cost after the speech occurs. New York Times Company v. Sullivan, 376 U.S. at 267, and subjecting the speaker to criminal penalties. Brandenburg versus Ohio, 395 U.S. 444, 445, 1969, per curiam. The law before us is an outright ban, backed by criminal sanctions. Section 441b makes it a felony for all corpora. Tie-ins, including non-profit advocacy corporations, either to expressly advocate the election or defeat of candidates or to broadcast electioneering communications within 30 days of a primary election and 60 days of a general election. Thus, the following acts would all be felonies under Section 441b. The Sierra Club runs an ad, within the crucial phase of 60 days before the general election, that exhorts the public to disapprove of a congressman who favors logging in national forests. The National Rifle Association publishes a book urging the public to vote for the challenger because the incumbent U.S. senator supports a handgun ban, and the American Civil Liberties Union creates a website telling the public to vote for a president. Opinion of the court. Tile candidate in light of.
But so is this their example that they're trying to go? Start the reading.
IBA.
Wow. Okay, sure. Read aloud there, please. Uh-oh, it broke.
Opinion of the court. Tile candidate in light of that candidate's defense of free speech. The law before us is an outright ban, backed by criminal sanctions. Section 441B makes it a felony for all corporations, including non-profit advocacy corporations, either to expressly advocate the election or defeat of candidates or to broadcast electioneering communications within 30 days of a primary election and 60 days of a general election. Thus, the following acts would all be felonies under Section 441B. The Sierra Club runs an ad, within the crucial phase of 60 days before the general election, that exhorts the public to disapprove of a congressman who favors logging in national forests. The National Rifle Association publishes a book urging the public to vote for the challenger because the incumbent U.S. senator supports.
Oh my god, how hard is this not to... Yeah, fuck the Sierra Club, fuck the National Rifle Association, whether I agree with them or not. They are not individuals using their mouth and brain to do speaking. They are giant multi-million-dollar groups, and in the case of the NRA, I'm pretty sure it's more than that. Definitely hundreds of millions, if not tens. You know what, fine. I'm gonna Google how money NRA. Open Secrets. What a classic. So each damn year? You're spending this much? What about all time? Oh my god. Well, I guess I'm not wrong. It is the scale of hundreds of millions. Not that you can see it, it's showing you whatever. Right now, it looks like my thing even froze, which is not good. I opened a new tab, that's what happened. Oops. Right, there we go, there's that. Wait, again, how much was it? Hundreds of millions? Yeah, okay. No, I don't think those people should be allowed to speak on elections. They're not people. They're goddamn multi-million-dollar businesses. I don't care if they're non-profit or for-profit. It's the same thing. I think that should be something that shouldn't be allowed if you're going to argue that this is a democracy.
Supports a handgun ban, and the American Civil Liberties Union creates a website telling the public to vote for a president.
Yes, even the ACLU. I don't think that giant corporations should be allowed to release propaganda like this, influencing presidential campaigns, if not any campaigns. I don't think that should be how it could be. No, like I don't really think political parties should be allowed to either. Like I'm crazier. And I don't know, I'm not a big fan, especially this like I'm not a big fan of saying like, ooh, just ban it. I'm just saying like let's create new systems that are better than this. For enabling free speech. Let's not just stay out of the way of it. Let's create systems that prop up free speech of individuals and empower individuals to speak freely. And in a way that uses modern technologies to do it. Oh. Alright, how the hell do I get out of here? Because I have no memory of how any of this weird place works in the game. I'm going to go back to reading. I wonder what page I'm on. I literally cannot see. Control F. Oh, 21. Wow. Okay, I'm going to die. I will never finish this.
3. The First
It'll take
Amendment
days.
provides that Congress shall make no law abridging the freedom of speech. Laws enacted to control or suppress speech may operate at different points in the speech process. The following are just a few examples of restrictions that have been attempted at different stages of the speech process. All laws found to be invalid. Restrictions requiring a permit at the outset. Watchtower Bible and Tract Associa of N.Y. Inc. v. Village of Stratton, 536 U.S. 150, 153, 2002. Imposing a burden by impounding proceeds on receipts or royalties. Simon & Schuster Incorporated v. Members of N.Y. State Crime Victims B.D. 502 U.S. 105, 108, 123, 1991, seeking to exact a cost after the speech occurs. New York Times Company v. Sullivan, 376 U.S. at 267, and subjecting the speaker to criminal penalties. Brandenburg v. Ohio, 395 U.S. 444, 445, 1969, per curiam. The law before us is an outright ban, backed by criminal sanctions. Section 441B makes it a felony for all corpora. Tie-ins, including non-profit advocacy corporations, either to expressly advocate the election or defeat of candidates or to broadcast electioneering communications within 30 days of a primary election and 60 days of a general election. Thus, the
They do
following
repeat
acts
the
would
same
all be
thing like
felonies
15
under
times.
Section 441B. The Sierra
What?
Club runs an ad
Wait, why?
within the
What
crucial
happened?
phase of 60.
No, it actually read this once before. I don't need to read this again. What's going on? So again, Section 441B is part of the law connected to campaign finance reform.
Section 441B is a ban on corporate speech notwithstanding the fact that a PAC created by a corporation can still speak. C. McConnell, 540 U.S., at 330 to 333, opinion of Kennedy, J. A PAC is a separate association from the corporation. So the PAC exemption from Section 441B's expenditure ban, Section 441B, B2, does not allow corporations to speak. Even if a PAC could somehow allow a corporation to speak, and it does not, the option to form PACs does not alleviate the First Amendment problems with Section 441B. PACs are burdensome alternatives, they are expensive to administer and subject to extensive regulations. For example, every PAC must appoint a treasurer, forward donations to the treasurer promptly, keep detailed records of the identities of the persons making donations, preserve receipts for 3 years, and file an organization statement and report changes to this information within 10 days. CID, at 330 to 332, quoting MCFL, for 79 U.S., at 253 to 254. And that is just the beginning. PACs must file detailed monthly reports with the FEC.
I'm not surprised that PACs have to be well regulated, but I don't even think they should exist at all, and I feel like that should be common sense.
These reports must contain information regarding the amount of cash on hand, the total amount of receipts, detailed by 10 different categories, the identification of each political committee and candidates authorized or affiliated committee making contributions, and any persons making loans, providing rebates, refunds, dividends, or interest or any other offset to operating expenditures in an aggregate amount over $200, the total amount of all disbursements, detailed by 12 different categories, the names of all authorized Citizens United v. Federal Elections COMMN opinion of the court, or affiliated committees to whom expenditures aggregating over $200 have been made, persons to whom loan repayments or refunds have been made, the total sum of all contributions, operating expenses, outstanding debts and obligations, and the settlement terms of the retirement of any debt or obligation. 540 U.S. at 331 to 332, quoting MCFL, Supra, at 253 to 254.
Their meaning of the word speak is so crazy.
Regulations just to speak. This might explain why fewer than 2,000 of the millions of corporations in this country have PACs. See brief for 7 former chairman of FEC et al. As Amici Curiae 11, citing FEC, Summary of PAC Activity 1990 to 2006, online athpa/www.fec.gov/press/press 2007/20071009.
Oh, okay, wow. Alright, we're reading a link. This is a lot.
2006, Corporation Income Tax Returns 2, 2009, hereinafter Statistics of Income, 5.8 million for-profit corporations filed 2006 tax returns. PACs, furthermore, must exist before they can speak. Given the onerous restrictions, a corporation may not be able to
Onerous.
establish a PAC in time to make its views
I
known
don't hear
regarding
on very
candidates
often.
and issues in a current campaign. Section 441B's prohibition on corporate independent expenditures is thus a ban on speech. As a restriction on the amount of money a person or group can spend on political communication during a campaign, that statute necessarily reduces the quantity of expression by restricting the number of issues discussed, the depth of their exploration.
Whoa, whoa, whoa. Okay, this might be super relevant for when I actually make the video. Is thus a ban on speech. It's a restriction on the amount of money a person or group can spend on political communication during a campaign. Person or group can actually don't really see what they're saying. Wow, this is one of the first times I don't understand what they're saying at all. Reduces quantity of expression. I understand like the analogy that they're making, but what do I not know about section 441B that says that? What am I not getting? For effective public communication requires the speaker to make use of the services of others. That's interesting logic. If 441B applied to individuals, no one would believe that it is merely a time, place, or manner restriction of speech. Its purpose and effects are to silence entities whose voices the governments deem to be suspect. That sounds really fucking reasonable. We should assume that all groups with that much wealth are necessarily suspect. What? Why not? Speech is an essential mechanism of democracy, for it means to hold officials accountable to the people. See Buckley. In a republic where the people are sovereign, the ability of the citizenry to make informed choices among candidates for office is essential. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to the enlightened self-governed. Yeah. Okay, now they're getting into Kant. I think it was Immanuel Kant who was obsessed with this. No, who was the guy that... I do not remember. Let me try to remember this. The philosopher that insisted on free speech for a working... Was it not Immanuel? Strongly advocated for free speech as a cornerstone. Free speech is a tool for individuals to access public sphere. Like, yeah, I remember one of these guys. Yeah, it looks like it. Definitely looks like that was the last one I read, who had a very long speech about how free speech is necessary for the success of a functioning democracy. I do not disagree whatsoever. But if it's going to be free, it needs to also be equal. It's simple as that, right? No one person, because they have more wealth, should have more access to speech than anyone else. That it's simple as that. All right, I'm going to take a break for a second and then continue reading. I haven't done this yet, but I'm going to leave voice detect. Page 30 of 183. Okay, so that's 3, 6, 9, 12, 15, 18. So I am 1/6 of the way through right now, and I have been streaming for... Good question. How long have I been? 2 hours. I'm 1/6. Oh my god, that means this whole paper would be 12 hours. Well, it's not like I haven't done stuff like this before, so I might as well get used to it. This is definitely going to be like a week of tiny streams, stitched together. If I want to have any chance of Actually, having read all of this, okay, all right, I'm gonna take a break for a sec and then get back to it. Flipping the microphone for the 15th time. Really does suck that I have to reset up all this crap every time I want to get up for a second. Putting the glasses on, putting my headphones on, and now I'm grabbing my mouse again. Holy cow, this is so much work. Every time. Hopefully it's not cloudy out right now. I've had the AC running the entire time. Okay, back to reading. Well, the next section is pretty interesting. I was reading it ahead on purpose. Here we go. Speech is an essential mechanism of democracy.
Opinion of the court. And dissemination of ideas for effective public communication requires the speaker to make use of the services of others. If Section 441 be applied to individuals, no one would believe that it is merely a time, place, or manner restriction on speech. Its purpose and effect are to silence entities whose voices the government deems to be suspect. Speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the people. See Buckley, Supra, at 14-15, in a republic where the people are sovereign, the ability of the citizenry to make informed choices among candidates for office is essential. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlightened self-government and a necessary means to protect it. The First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. EU versus San Francisco County Democratic Central Com, 489 U.S. 214, 223, 1989, quoting Monitor Patriot Company v. Roy, 401 U.S. 265, 272, 1971, C. Buckley, Supra, at
Oh my
14,
god, how many numbers are they going
public
through?
issues and debate on the qualifications of candidates are integral to the operation of the system of government established by our Constitution. For these reasons, political speech must prevail against laws that would suppress it, whether by design or inadvertence. Laws that burden political speech are subject to strict scrutiny, which requires the government to prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. WRTL 551. U.S. at 464, opinion of Roberts, C.J. While it might be maintained that political speech simply cannot be banned or restricted as a categorical matter, see Simon and Schuster, 502
Oh, the J
U.S.
definitely
at
means Chief Justice. I'm
124,
just
Kennedy,
stupid.
J. Concurring in judgment, the quoted language from WRTL provides a sufficient framework for protecting the relevant First Amendment interests in this case. We shall employ it. Citizens United v. Federal Elections COMMN. Opinion of the court. Here. Premised on mistrust of governmental power, the first. Quite apart from the purpose or effect of regulating content, moreover, the government may commit a constitutional wrong when by law it identifies certain preferred speakers. By taking the right to speak from some and giving it to others, the government deprives the disadvantaged person or class of the right to use speech to strive to establish worth, standing, and respect for the speaker's voice.
Oh,
The government may not by these means deprive the
definitely in the
public
wrong
of the
place.
right and privilege to determine for itself what speech and speakers are worthy of consideration. The First Amendment protects speech and speaker, and the ideas that flow from each. The court has upheld a narrow class of speech restrictions that operate to the disadvantage of certain persons, but these rulings were based on an interest in allowing governmental entities to perform their functions. See, e.g., Bethel School DST number
They're
403 D.
mentioning
Fraser,
the rights of
478 U.S.
students and
675,
prisoners to have free speech. Wow, to perform their duties. Oh no, this is crazy. I didn't expect it to connect back to stuff I know about. Bethel School District. Yeah, limiting the function of a public school is more important than free speech. Theological objectives of the correction system. No quotation.
683, 1986, Protecting the Function of Public School Education, Jones versus North Carolina.
So children
Prisoners
aren't
Labor
allowed
Union
free speech
Incorporated,
on the basis of them being children.
129,
But billionaires are allowed free
1977,
speech
furthering the
on the basis of
legitimate objectives
their
of the
wealth being
correction
more
system,
important
internal
than a
quotation
child
marks
happening to be
omitted.
young.
Parker versus Levy,
Love it.
417 U.S.
That's-
733,
Wow, I feel like I could make an entire video on that comparison alone.
Ensuring the capacity of the government to discharge its military responsibilities, internal quota. Tie-in marks omitted.
Cool
Civil
tie-in.
Service Com NV. Letter carriers, 413 U.S. 548, 557, 1973, F. Federal service should depend upon meritorious performance rather than political service. The corporate independent expenditures at issue in this case, however, would not interfere with governmental functions, so these cases are inapposite. These precedents stand only for the proposition that there are certain governmental functions that cannot operate without some restrictions on particular kinds of speech. By contrast, it is inherent in the nature of the political process that voters must be free to obtain information from diverse sources in order to determine how to cast their votes. At least before Austin, the court had not allowed the exclusion of a class of speakers from the general public dialogue. We find no basis for the proposition that, in the context of political speech, the government may impose restrictions on certain disfavored speakers. Both history and logic lead us to this conclusion. 1. The court has recognized that First Amendment protection extends to corporations. Bellotti, Supra, at 778, N14, citing Linmark Associates Incorporated v. Willenboro, 431 U.S. 85, 1977, Time Incorporated v. Firestone, 424 U.S. 448, 1976, Doran v. Salem and Incorporated, 422 U.S. 922,
That was scary.
1975, Southeastern Promotions, Limited v. Conrad, 420 U.S. 546, 1975, Cox Broadcasting Corporation v. Cone, 420 U.S. 469.
Good God, no wonder lawyers need like 8 years
Miami
of
Herald
school. This shit
Publishing
is
Company v.
just
Tornado,
insane.
418 U.S.
The sheer amount of
241.
crap.
1974, New York Times Company v. United States, 403 U.S. 713, 1971, Per Curiam. Time Incorporated v. Hill, 385 U.S. 374.
Oh my God, it's still going.
1967.
Holy
New York.
crap!
Times Company v. Sullivan, 376.
Genuinely, this has to be why it takes fucking like 10 years to become a lawyer. This is terrible.
University of NY, 360.
Oh my God.
684, 1959. Joseph Burston Incorporated via Wilson, 343 U.S. 495, 1952.
Man, I can't see
CEG,
nothing.
Turner Broadcasting
Oh, that looks
System
interesting.
Incorporated v. FCC.
Ooh, reinforced dive suit. That would be nice. I'm
Citizens
pretty sure
United
that'll make
v.
it so I
Federal
don't die in
Election,
hot water.
COMMN.
That will be useful later.
Opinion of the court. 520 U.S. 180, 1997, Denver Area Ed Telecommunications Consortium
Denver.
Incorporated via FCC, 518 U.S. 727, 1996, Turner, 512. U.S. 622, Simon & Schuster, 502 U.S. 105, Sable Communications of Cal, and VFCC, 492 U.S. 115.
Oh my God, it's still going. It's going to be like another
Florida Star versus
half page
BJ,
of just mentioning
491
other
US,
cases.
524,
That's
1989.
that's impressive.
Philadelphia Newspapers Incorporated v. Heps, 475 U.S. 767, 1986.
Still going. This is incredible.
Landmark Communications Incorporated via Virginia, 435 U.S. 829, 1978. Young vs. American Mini Theaters Incorporated, 427 U.S. 50, 1976. Gertz vs. Robert Welch
Oh, a
Incorporated.
diamond! Whoa, that took forever.
323,
Oh, looks like I figured out a place to go.
Cooperative Publishing Association,
Finally.
and V. Bressler, 398 U.S. 6, 1970. This protection has been extended by explicit holdings to the context of political speech. See,
Hey, get off!
371 U.S. at 428 to 429. Grosjean
That's
versus
scary.
American Press Company.
Lithium, I need that too. What the heck? This area has so much good stuff.
1936.
And a lot of things that want to kill me
Under
at the same time. That's crazy.
Political speech
Not a huge
does
fan
not
of
lose
that.
First
But
Amendment
whatever.
protection simply because its source is a corporation.
Why does this area have every single material in the game at the same time?
Pacific Gas and Elec Company v. Public Util. Comment of Cal 475 U.S. 1.
It's the entrance to the
Morality opinion.
scary
The
area.
identity of the speaker is not decisive in determining whether speech is protected. Corporations and other associations, like individuals, contribute to the discussion, debate, and the dissemination of information and ideas that the First Amendment seeks to foster.
Oh, my inventory's full, and I'm running out of air. So let's get
783. The court has thus rejected the argument that political speech of corporations or other associations should be treated differently under the First Amendment simply because such associations are not natural persons. ID at 776, CID at 780 and 16.
Okay, what is this?
CF.
The court has thus rejected the argument that political speech of corporations or other associations should be treated differently under the First Amendment simply because such associations are not natural persons. Why would you reject that? Why do you think a real flesh human being with a soul to you guys? I don't really believe in souls, but in these guys' minds, a soul and a mind and a heart and a destiny or whatever, like a real human being is equatable with a damn business? Like individuals contribute to the discussion, debate, and dissemination of information and ideas that the First Amendment seeks to foster. No, corporations should not be allowed to contribute to the realm of human beings. No. Wait, oh my God.
ID at 828, Rehnquist, J, dissenting. At least since the latter part of the 19th century, the laws of some states and of the United States imposed a ban on corporate direct contributions to candidates. C. B. Smith, Unfree Speech, The Folly of Campaign Finance Reform 23, 2001. Yet not until 1947 did Congress first prohibit independent expenditures by corporations and labor unions in Section 304 of the Labor Management Relations Act 1947, 61 Stat 159, codified at 2 U.S.C. Section 251, 1946 edition, Sup. 1. In passing this
I
act,
already had
Congress
diamonds.
overrode
Well,
the veto
I should have seen that
President
coming a long
Truman,
time ago.
who warned that the expenditure ban was a dangerous intrusion on free speech. Message from the President of the United States, H.R. Document Number 334, 89th Cong, First Session, 9, 1947. For almost 3 decades thereafter, the court did not reach the question whether restrictions on corporate and union expenditures are constitutional. See WRTL 551. U.S. at 502, Opinion of Scalia, J. The question was in the background of United States v. CIO, 335 U.S. 106, 1948. There, a labor union endorsed a congressional candidate in its weekly periodical. The court stated that the gravest doubt would arise in our minds as to the federal expenditure prohibitions, constitutionality if it were construed to suppress that writing. ID at 121. The court engaged in statutory interpretation and found the statute did not cover the publication. ID at 121 to 122 and Endpoint 20, for justices, however, said they would reach the constitutional question and invalidate the Labor Management Relations Act's expenditure ban. ID at 155, Rutledge, J, joined by Black, Douglas, and Murphy, JJ, concurring in result. The concurrence explained that any undue influence generated by a speaker's large
I have to
expenditures
find
was
data to
outweighed
make an
by the
ion
loss for
battery. That's
democratic processes resulting from the restrictions upon free and full public discussion. ID at 143. In United States versus Automobile Workers, 352 U.S. 567, 1957, the court again encountered the independent expenditure ban, which had been recodified at 18 U.S.C. Section 610, 1952 edition. See 62 Stat 723 to 724. After holding only that a union television broadcast that endorsed candidates was covered by the statute, the court, FEC did, to anticipate constitutional questions and remanded for the trial to proceed. 352 U.S. at 591. 3 Justices dis. Citizens United v. Federal Elections COMMN. Opinion of the court. Scented, arguing that the court should have reached the constitutional question
everything
and
to
that the
make
ban
it
on
now.
independent
Cool.
expenditures was
Gotta
unconstitutional.
put away all this other gear.
Under our Constitution, it is we the people who are sovereign. The people have the final say. The legislators are their spokesmen. The people determine through their votes the destiny of the nation. It is therefore important, vitally important, that all channels of communications be open to them during every election, that no point of view be restrained or barred, and that the people have access to the views of every group in the community. ID at 593, opinion of Douglas, J., joined by Warren, C.J., and Black, J. The dissent concluded that deeming a particular group too powerful was not a justification, and, for withholding First Amendment rights from any group, labor or corporate.
Better make a reactor rod.
ID at
Aluminum and glass.
597.
Cool.
The court did not get
Use
another
up some
opportunity
materials.
to consider the constitutional question in that case, for after a remand, a jury found the defendants not guilty. C. Hayward, Revisiting the Fable of Reform, 45 Harv. J. Legis, 421, 463,
I can use it.
2008. Later, in Pipefitters vs. United States, 407 U.S. 385, 401, 1972, the court reversed a conviction for expenditure of union funds for political speech, again without reaching the constitutional question. The court would not resolve that question for another 4 years. 2 in Buckley, for 24 U.S. 1, the court addressed various challenges to the Federal Election Campaign Act of 1971, FECA, as amended in 1974. These amendments
There we
created
go. Reactor
18
rods are
U.S.C.
made. Easy.
Section 608E, 1970 edition,
Put that in
Subdivision
here.
C88 Stat 1265, an independent expenditure ban separate from Section 610 that applied to individuals as well as corporations and labor unions. Buckley, 424 U.S., at 23, 39, and N 45. Opinion of the court. Before addressing the constitutionality of Section 608E(s) independent expenditure ban, Buckley first upheld Section 608B, FECA's limits on direct contributions to candidates. The Buckley court recognized a sufficiently important governmental interest in the prevention of corruption and the appearance of corruption. ID at 25, CID at 26. This followed from the court's concern that large contributions could be given to secure a political quid pro quo. IBID. The Buckley court explained that the potential for quid pro quo corruption distinguished direct contributions to candidates from independent expenditures. The court emphasized that the independent expenditure ceiling fails to serve any substantial governmental interest in stemming the reality or appearance of corruption in the electoral process, ID, at 47 to 48, because, the absence of pre-arrangement and coordination alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate, ID. At 47. Buckley invalidated Section 608E(s) restrictions on independent expenditures, with only one justice dissenting.
And, oh, I need
See
light.
Federal Election
And
Comment
I'm going
v.
up top
National
and I'm
Conservative
making this.
Political Action
I'm gonna
Com.
drop it down a million
470
feet.
U.S. 480, 491, N3, 1985, Impact. Buckley did not consider Section 610's separate ban
Straight
on
up top.
corporate and union independent expenditures, the prohibition that had also been in the background in CIO, automobile workers, and pipefitters. Had Section 610 been challenged in the wake of Buckley, however, it could not have been squared with the reasoning and analysis of that precedent. See WRTL, Supra, at 487, opinion of Scalia, J. Buckley might well have been the last word on limitations on independent expenditures. Austin, 494 U.S., at 683, Scalia, J., dissenting. The expenditure ban invalidated in Buckley, Section 608E, applied to corporations and unions,
Let's get this
424
thing made.
U.S., at 23, 39, and 45, and some of the prevailing plaintiffs in Buckley were corporations, ID, at 8. The 30 Citizens United v. Federal Elections COMMN. Opinion of the court.
Well, there it goes.
Buckley Court did not invoke the First Amendment's overbreadth doctrine.
Oh,
See
I
Broderick
have a
versus
thing.
Oklahoma, 413. U.S. 601, 615, 1973, to suggest that Section 608E(s) expenditure ban would have been constitutional if it had applied only to corporations and not to individuals, 424 U.S. at
Okay, it's still falling. That's fine.
Buckley cited with approval the automobile workers' dissent, which argued that Section 610 was unconstitutional.
Oh, there it goes.
424. U.S.
Prawn
at 43,
suit.
citing 352 U.S. at 595 to 596, opinion
To
of
upgrade
Douglas
a lot
J.
of its stuff first, but
Notwithstanding this precedent,
I'll get it made.
Congress recodified Section 610's corporate and union expenditure ban at 2 U.S.C. Section 441b 4 months after Buckley was decided. C90 Stat. 490. Section 441b is the independent expenditure restriction challenged here. Less than 2 years after Buckley, Bellotti, 435 U.S. 765, reaffirmed the First Amendment principle that the government cannot restrict political speech based on the speaker's corporate identity. Bellotti could not have been clearer when it struck down a state.
Okay, less than 2 years after Buckley, Bellotti 435 U.S. 765 reaffirmed the First Amendment principle that the government cannot restrict political speech based on the speaker's corporate identity. Oh my God, Bellotti could not have been clearer when it struck down a state law prohibition on corporate independent expenditures related to referenda issues. Oh my God. Man, is it gay and trans people that focus too much on our identities, or is it fucking capitalists? Because holy shit, being corporate is literally an identity characteristic according to these people. According to American case law, it's insane. They won't recognize
State law
trans, but they'll
prohibition on
recognize if you're a
corporate
corporation.
independent expenditures related to referenda issues.
You know what's
We thus
fucked up?
find no support in the
Trans people have been around for like all of human society, 100,000 years or something, right? In fucking what is it called? The Epic of Gilgamesh. There's a god, which in parentheses has es at the end, a goddess, but god named Inanna, which I forget the other version of the name, but there's a god that like is the god of fertility, but also it's like the god of being trans. It's a god of like turning men into women and women into men, and it's a character that manifests as different genders each time, kind of like the way that Hermes is a hermaphrodite. Using the Latin root word for hermaphrodite there, what we would say now is obviously an intersex person. But the existence of gender nonconforming people, whether that be by personality, whether that be by soul, looking to things like two-soul in Native American culture, or two-spirit in Native American culture, or looking at these sort of gender and sexually ambiguous gods and goddesses throughout history, like Inanna, the existence of what we now call trans people, or queer people, or gender nonconforming people, or not cis people, that has been around for hundreds of thousands of years. And it is impossible right now, as I record this stream, to get the existence of such people recognized by the government. And yet, the concept of a corporation in America, which has only been around for like 200 years at best, if not like 100, is recognized by the Supreme Court as existing. And a corporation is given more rights and more acknowledgement by the government than a trans person. I cannot. Dystopia. There you go. I don't know. I'm gonna keep playing. Dystopia.
Amendment, or in
Oh
the
boy.
decisions of this court, for the proposition that
I have a
speech that
fish.
otherwise would be within the protection of the First Amendment loses that protection simply because its source is a corporation that cannot prove, to the satisfaction of a
I have a
court,
fish.
a material effect on its business or property. That proposition amounts to an impermissible legislative prohibition of speech based on the identity of the interests that spokesmen may represent in public debate over controversial issues and a requirement that the speaker have a sufficiently great interest in the subject to justify communication.
Oh, I'm getting hungry,
Opinion of the
unfortunately.
court. In the realm of protected speech, the legislature is constitutionally disqualified from dictating the subjects about which persons may speak and the speakers who may address a public issue. ID at 784 to 785. It is
Am I
important
close
to
enough?
note
I
that the
am. Good
reasoning
job.
and holding of Bellotti did not rest on the existence of a viewpoint discriminatory statute. It rested on the principle that the government lacks the power to ban corporations from speaking. Bellotti did not address the constitutionality of the state's ban on corporate independent expenditures to support candidates. In our view, however, that restriction would have been unconstitutional under Bellotti's central principle that the First Amendment does not allow political speech restrictions based on a speaker's corporate identity. See Ibid. 3. Thus the law stood until Austin. Austin of ELD, a direct restriction on the independent expenditure of funds for political speech for the first time in this court's history. 494 U.S. at 695, Kennedy, J. dissenting. There,
It's an
the
efficiency
Michigan Chamber
module.
of Commerce sought to use
I
general treasury
need
funds to run a
the
newspaper ad
Cyclops Death
supporting a
Module
specific
1,
candidate.
and I'm going to
Michigan law,
comfortably
however,
and not
prohibited
ashamedly
corporate
Google where that
independent
is, because
expenditures that supported
every
or
time I've
opposed
ever
any
played this video
candidate for
game,
state
I cannot
office.
find
A
that
violation of the
specific
law
dev
was
module.
punishable as a felony. The court sustained the speech prohibition.
Module 1,
To
look.
bypass Buckley and Bellotti, the Austin court
I can never
identified a new
find it.
governmental interest in limiting political speech, an anti-distortion interest. Austin found a compelling governmental interest in preventing the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public
Upgrade
sub.
module.
Citizens
400.
United v. Federal Elections COMMN. Opinion of the court. Port for the corporation's political ideas.
Upgrade.
494 U.S. at
What?
660, CID at
What
659,
How does
citing
this work?
MCFL. 479 U.S.
Right,
at
isn't it that the
257, PAC,
machine itself
470
has a...
U.S. at 500 to 501. B. The court is thus confronted with conflicting lines of precedent, a pre-Austin
Right,
line
there,
that
it has
forbids
its own built-in
restrictions on
fabricator or
political
something
speech
like
based
that?
on the
What am I not
speaker's corporate
understanding?
identity, and a post-Austin line that permits them. No case before Austin had held that Congress could prohibit independent
Oh,
expenditures
yes. See,
for
I
political
never
speech
remember
based
that
on the
this
speaker's
exists.
corporate identity.
Last deal and get plus 3 rubies.
Before
Good
Austin,
God,
Congress
this is
had
so
enacted
complicated for me.
legislation for this purpose, and the government urged the same proposition before this court. CMCFL,
Yeah, I never
Supra,
remember that
at
that even exists every
257,
time I play.
FEC posited that Congress
Consistently,
intended
I
to
could
curb the
swear that you have to
political
do it
influence of
in
those who
your
exercise control over
normal
large
thing over
aggregations
here.
of capital, quoting automobile workers.
How do I
Supra,
make a
at
plasteel ingot real quick? I
585,
need
California
some
Medical
lithium, which I've had very
Association
little
v.
of
Federal
recently.
Election Comment, 453 U.S. 182, 201, 1981. Congress believed that
I've got a
differing
normal one
structures
of
and
those.
purposes of corporations and unions may require different forms
Got
of
some lithium
regulation
down
in order
here.
to protect the integrity of the electoral process. Neither of these
There's
cases
one
did the
lithium. I'm
court
pretty sure I
adopt
need
the
more than that.
proposition. In its defense of the corporate speech restrictions in Section 441B, the government notes the
Okay, I need
anti-distortion
more.
rationale on
Going
which
down.
Austin and its progeny rest in part,
I'm
yet
gonna
it all
save,
but
it's been a
abandons
while.
reliance upon it. It argues instead that two other compelling interests support Austin's holding that corporate expenditure restrictions are constitutional: an anti-corruption interest, see 494 U.S. at 678, Stevens, J. concurring, and a shareholder protection interest, CID, at 674 to 675, Brennan, J. concurring.
Take extra diamonds where I can
We
get...
consider the 3 points in turn.
Oh, cool. That's huge.
One is for Austin's anti-distortion rationale, the government. Opinion of the court. Does little to defend it. CTR of Oral Arg 45 to 48, September 9, 2009. And with good reason, for the rationale cannot support Section 441B. If the First Amendment has any force, it prohibits Congress from fining or jailing citizens, or associations of citizens, for simply engaging in political speech. If the anti-distortion rationale were to be accepted, however, it would permit government to ban political speech simply because the speaker is an association that is taken
Interesting
on the
though, I'm
corporate
pretty sure
form.
that police can arrest
The
you for pretty
government
much
contends that
any
Austin
semblance
permits it
of
to ban
obstruction or
corporate
disturbance,
expenditures for
even if
almost
you
all
are just
forms
doing
of
free speech.
communication stemming from a corporation. See
Pretty
Part
sure I've
2E,
watched that in
Secret
videos about
PR
30
Oral Art
times.
66, September
Usually
9,
charge you with obstruction.
2009. See also ID
Obstructing
26 to
justice by
31,
speaking
March
freely.
24, 2009. If Austin were correct, the
There are no
government could
rules.
prohibit a corporation
These
from
people think that
expressing
they're like
political views in
morally
media beyond
exceptional
those presented here,
or
such as by
following
printing
some
books.
consistent system
The
of
government
logic for their
responds that
morals,
the
but no,
FEC has never
there are
applied
no
this
rules.
statute to a book, and if it
There
did,
are
there would be quite
principles and
a good
beliefs,
stoplight challenge.
and thinking that any
TR
of these
of
things are
Oral Art
guaranteed is
65,
ridiculous.
September 9, 2009.
Thinking that
This
any of the
troubling
existing
assertion
systems of
brooding
law that we've
governmental
used
power
are going to achieve these outcomes
cannot be
is
reconciled
absurd
with
to
the
me.
confidence and stability in civic discourse that the First Amendment must secure. Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual. Bellotti, 435 U.S., at 777, footnote omitted, see IBID, the worth of speech does not depend upon the identity of its source, whether corporation, association, union, or individual. Buckley, 424 U.S., at 48 to 49, t. The concept that government may restrict the speech of some elements of
Political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual. That's Bellotti, 435 U.S. at 777, footnote omitted, see IBID. The worth of speech does not depend upon the identity of the source of its source, whether corporation, association, union, or individual. Buckley. I feel like it's said like the same thing about 20 different times. I have moved forward in pages, but I swear I've heard the exact same thing about 20 different times, just repeated.
The court reaffirmed these conclusions when it invalidated the BCRA provision that increased the cap on contributions to one candidate if the opponent made certain expenditures from personal funds. See Davis versus Federal Election Comment, 554 U.S. _____________,
Oh, okay,
2008,
they're saying
slip
underscore a
up,
lot.
at 16, leveling electoral opportunities means making and implementing judgments about which strengths should be permitted to contribute to the outcome of an election. The Constitution, however, confers upon voters, not Congress, the power to choose the members of the House of Representatives, Art.
To be
Section
module
2,
1,
and it
and
is a
immediately
dangerous
upgrade it
business for Congress to
higher.
use the election laws to
Oh
influence the
no,
voters'
I'll have to go
choices.
get nickel first. That's
The
going to
rule
be
that
really
political
difficult.
speech
Okay, I
cannot
have
be
to go to
limited
the
based
Lost
on a
River
speaker's
ASAP.
wealth is a necessary consequence
First,
of
I'll
the
need a moon
premise that
pool,
the
and
First
for a moon
Amendment
pool, I'll need a
generally
power
prohibits the
station.
suppression of political speech based on the speaker's identity.
I'm gonna have to build a house real quick
Either
right
as
here
support
to
for
upgrade
its
my stuff.
anti-distortion rationale or as a further argument, the Austin majority undertook to distinguish wealthy individuals from corporations on the ground that Tate Law
Oh, I might
grants
as well go put this
corporations
in.
special ad. Opinion of the
I
court.
have it in somewhere.
Advantages such as limited liability, perpetual life, and favorable treatment of the
There's Mark 1.
accumulation and distribution of
900,
assets.
it's pretty deep. Cool.
494 U.S. at
Issue
658 to
is, how deep can
659.
my prawn go?
This does not suffice, however, to allow laws prohibiting speech. It is rudimentary that the state cannot exact as the
I do
price
not
of
know
those
how
special
deep this goes.
advantages
It
the
definitely needs to go
forfeiture
to
of
like
First Amendment
900,
rights.
around 1,000.
ID at
900,
680,
okay, cool.
Scalia, J, dissenting.
That's good enough.
It is
as
irrelevant
it
for
is.
purposes of the First Amendment that corporate funds may have little or no correlation to the public's support for the corporation's political ideas. ID at 660, majority opinion. All speakers, including individuals and the media, use money amassed from the economic marketplace to fund their speech. The First Amendment protects the resulting
Based on
speech,
that, I'm ready to
even
go
if it was
straight
enabled
down.
by
The issue
economic
is,
transactions with persons or
where am I
entities who
going to get
disagree
depth
with the speaker's
modules
ideas.
for the
CID at 707,
prawn
Kennedy,
suit?
J, dissenting, many persons can trace their funds to corporations, if not in the form of donations, then in the form of dividends, interest, or salary. Austin's anti-distortion rationale would produce the dangerous and unacceptable consequence that Congress could ban political speech of media corporations. C. McConnell, 540 U.S., at 283, opinion of Thomas, J.
My God.
The chilling
So hard
endpoint
to
of the
get a hold of
court's
these.
reasoning is not difficult to foresee: outright regulation of the press. CF Tornillo, 418
Alright, I
US,
just need to get
at
down. I need to get into the
250,
loss.
alleging the existence of vast accumulations of unreviewable power in the modern media empires. Media corporations are now exempt from Section 441b's ban on corporate expenditures. C2 U.S.C. Sections 431, 9,
Dude,
B,
fuck a
I,
media corporation
434,
too. I don't
F,
give a
3,
shit.
B, I. Yet
They're
media
all
corporations
giant and
accumulate wealth
significantly
with
more
the help of
wealthy
the
than
corporate
any
form.
individual
The
could ever
largest media
possibly be.
corporations have immense aggregations of wealth, and the views expressed by media corporations often have little or no correlation to the public's support for those views. Austin, 494 U.S., at 660. Thus, under the government's reasoning, wealthy media corporations. Citizens United v. Federal Elections COMMN. Opinion of the court. Could have their voices diminished to put them on par with other media entities. There is no precedent for permitting this under the First Amendment. The media exemption discloses further difficulties with the law now under consideration. There is no precedent supporting laws
I'm
that
at the point
attempt
where
to
like
distinguish between corporations which are deemed to be
I don't
exempt as
think that
media
like
corporations and those which are
this law
not.
shouldn't have been
We have
touched
consistently
or
rejected
relooked
the
at.
proposition that the institutional press has any constitutional privilege
The law that
beyond that of
is
other speakers.
the
ID at
Bipartisan Campaign
691,
Finance Reform
Scalia,
Act,
J. Dissenting,
RCA.
citing Bellotti,
I don't
435
think it
U.S.
didn't need
at
fixing.
782,
Yeah, I
Sundin and
see the
Bradstreet
risk. I
Incorporated v.
understand. I'm
Greenmoss Builders
comprehending. Like,
Incorporated,
hey,
472 U.S.
this could have led to
784, 1985.
this could have
Brennan,
led to a
J.,
problem.
joined by Marshall, Blackman, and Stevens, J.J. Dissenting, ID. At 773, White,
I
J.,
don't
concurring in
think
judgment.
that it was a flawless
With
piece of
the advent
legislation
of
that
the
should have been
internet
left
and the
alone
decline
forever.
of print and broadcast
But I think
media, moreover,
going
the
this
line between the
far and
media
saying
others
fuck
who
it,
wish to
all
comment on
corporations can
political
spend
and
money
social
on
issues become far more
advertising
blurred.
was stupid.
The law's exception for media
Two things can be true,
corporations is,
right?
on its own terms, all but an admission of the invalidity of the anti-distortion rationale. And the exemption results in a further, separate reason for finding this law invalid. Again, by its own terms, the law exempts some corporations but covers others, even though both have the need or the motive to communicate their views. The exemption applies to media corporations owned or controlled by corporations that have diverse and substantial investments and participate in endeavors other than news. So even assuming the most doubtful proposition that a news organization has a right to speak when others do not, the exemption would allow a conglomerate that owns both a media business and an unrelated business to influence or control the media in order to advance its overall business interest. At the same time, some other corporation, with an identical business interest but no media outlet in its ownership structure. Opinion of the court. Would be forbidden to speak or inform the public about the same issue. This differential treatment cannot be squared with the First Amendment. There is simply no support for the view that the First Amendment, as originally understood, would permit the suppression of political speech by media corporations. The framers may not have anticipated modern business and media corporations. See McIntyre v. Ohio Elections Comment, 514 U.S. 334, 360 to 361, 1995, Thomas, J., concurring in judgment. Yet television networks and major newspapers owned by media corporations have become the most important means of mass communication in modern times.
Okay, it's not the Supreme
First
Court's job to
Amendment was
fix
certainly
that,
not
but
understood
that
to
should
condone
not
the
be how we
suppression
do
of
it.
political speech in society's most salient media. It was understood as a response to the repression of speech in the press that had existed in England and the heavy taxes on the press that were imposed in the colonies. See McConnell, 540.
They literally did not have
U.S. at
the coming
252
foresight to
to
understand how
253, opinion
our
of
systems
Scalia,
for
J.A. Grosjean,
communicating ideas would change in
297.
time.
U.S. at 245 to 248, near 283 U.S. at 713 to 714. The great debates between the Federalists and the Anti-Federalists over our founding document were published and expressed in the most important means of mass communication of that era, newspapers owned by individuals. See
Yes,
McIntyre,
newspapers
514
owned by
US,
individuals.
At 341 to 343, ID, at 367, Thomas, J., concurring in judgment. At the founding, speech was open, comprehensive, and vital to society's definition of itself. There were no limits on the sources of speech and knowledge. C.B. Balin, Ideological Origins of the American Revolution 5, 1967. Any number of people could join in such proliferating polemics, and rebuttals could come from all sides. G. Wood, Creation of the American Republic 1776 to 1787, page 6, 1969. It is not surprising that the intellectual sources of the Americans' revolutionary thought were profuse and various. The framers may have been unaware of certain types of speakers or forms of Citizens United v. Federal Elections COMMN opinion of the court. Communication, but that does not mean that those speakers and media are entitled to less First Amendment protection than those types of speakers and media that provided the means of communicating political ideas when the Bill of
This thing
Rights
looks
was
angry.
adopted. Austin
Leave me alone.
interferes with the open marketplace of ideas protected by the First Amendment. New York State BD of Elections versus Lopez Torres, 552 U.S. 196, 208, 2008. CIBID, ideas may compete in this marketplace without government interference. McConnell, Supra, at 274, opinion of Thomas, J. It permits the government to ban the political speech of millions of associations of citizens. See Statistics of Income 2, 5.8 million for-profit corporations filed 2006 tax returns. Most of these are small corporations without large amounts of wealth. See Sub-Brief for Chamber of Commerce of the United States of America as Amicus Curiae 1, 3, 96% of the 3 million businesses that belong to the U.S. Chamber of Commerce have fewer than 100 employees. M. Cately, Congressional Research Service Report for Congress, Business Organizational Choices, Taxation and Responses to Legislative Changes 10, 2009, more than 75% of corporations whose income is taxed under federal law, see 26 U.S.C. Section 301,
What the
have
hell
less than
is
$1
that
million
doing out
in
here?
receipts per year. This fact belies the government's argument that the statute is justified on the ground that it prevents the distorting effects of immense aggregations of wealth. Austin, 494. U.S. at 660. It is not even aimed at amassed wealth. The censorship we now confront is vast in its reach. The government has muffled the voices that best represent the most significant segments of the economy. McConnell, Supra, at 257 to
Did they just say that out loud? Wait. The censorship we now confront is vast in its reach. The government has muffled the voices that best represent the most significant segments of the economy. No way. By suppressing the speech of manifold corporations, both for-profit and non-profit, the government prevents their voices and viewpoints from reaching the public and advising voters on which persons or entities are hostile to their interests. Oh my God, they're explicitly saying that free speech for corporations is important because how else are they going to trick people into voting to keeping the government from affecting their profit? Holy shit. I knew at some point this document would be useful. Page 46. Oh my God. They can just say that. By suppressing the speech of manifold corporations, both for-profit and non-profit, the government prevents their voices and viewpoints from reaching the public and advising voters on which person or entities are hostile to their interests. You know what's crazy? In the actual debate session that took place before this document was written, like a year or two before, I believe it was 2009, September of 2009 maybe, the lawyers for Citizens United, the lawyer for Citizens United, and a couple of other people all spoke to the Supreme Court and sort of hashed out their arguments. And one of the things that was said, oh, I just lost it because I got tired. Oh no. And it's hostility. Oh yeah, what was said explicitly by one of the justices or one of the other, government officials / lawyers, someone in this meeting said, well, everyone knows the singular goal of a corporation is to make a profit. That's it. They have one singular goal. It's to generate a profit for shareholders. That's the purpose of a corporation. And here they are saying the government should not prevent corporations from freaking speely. speaking freely, the justices are saying and concluding that the government should not prevent corporations from speaking freely, because otherwise, how are they going to convince voters to help them continue making a profit? How are they going to do that? They just said it here. This is kind of crazy if you look at it. How? Wow, 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 wow. Interesting. This is crazy.
Often, the government prevents their voices and viewpoints from reaching the public and advising voters on which persons or entities are hostile to their interests. Factions will necessarily form in our republic, but the remedy of destroying the liberty of some factions is worse than the disease. The Federalist No. 10, page 130, B. Wright edition 1961, J. Madison. Factions should be checked by permitting them all to speak, see Ibid, and by entrusting the people to judge what is true and what is false. The purpose and effect of this law is to prevent corporations, including small and non-profit corporations, from presenting both facts and opinions to the public. This makes Austin's anti-distortion rationale all the more an aberration. The First Amendment protects the right of corporations to petition legislative and administrative bodies. Bellotti, 435 U.S. at 792, N31, citing California Motor Transport Company via Trucking Unlimited, 404 U.S. 508, 510 to 511, 1972, Eastern Railroad President's Conference vs. Normotor Freight Incorporated, 365 U.S. 127, 137 to 138, 1961. Corporate executives and employees counsel members of Congress and presidential administrations on many issues, as a matter of routine and often in private. An Amici brief filed on behalf of Montana and 25 other states notes that lobbying and corporate communications with elected officials occur on a regular basis. Brief for State of Montana et al. As Amici Curiae 19. When that phenomenon is coupled with Section 441B, the result is that smaller or non-profit corporations cannot raise a voice to object when other corporations, including those with vast wealth, are cooperating with the government. That cooperation may sometimes be voluntary, or it may be at the demand of a government official who uses his or her authority, influence, and power to threaten corporations to support the government's policies.
Oh my God,
Those
so
kinds
the
of
easy
interactions
solution
are
should
often
just
unknown
keep the
and unseen.
corporations out of it altogether.
The speech that Section 441B forbids, though, is public, and all can judge its content and Citizens United v. Federal Elections COMMN opinion of the court. Purpose. References to massive corporate treasuries should not mask the real operation of this law.
Am I still getting attacked by a...
Rhetoric
Wow,
ought
that's
not
pretty bad.
obscure reality.
What if I
Even
just
if
ignore
Section
it?
441B's expenditure ban were constitutional, wealthy corporations could still lobby elected officials,
Fire!
although
Oh
smaller
shoot, I'm
corporations
about
may
to
not have
lose
the
my
resources to
freaking
do so.
boat.
And wealthy individuals and unincorporated associations can spend unlimited amounts on independent expenditures. See, e.g.,
Where's the fire? It said
WRTL
it detected a
551
fire. Where's the
US
fire?
503 to
Oh, here.
504,
Okay.
opinion of Scalia, J. In the 2004 election cycle, a mere 24 individuals contributed an astounding total of $142 million to 26 U.S.C. Section 527 organizations. Yet certain disfavored associations of
Wow.
citizens,
Oh my
those
God.
that have taken on the
Fire
corporate form, are
extinguished. Holy
penalized for
crap, that
engaging in
was
the
bad.
same political speech. When government seeks to use its full power, including the criminal law, to command where a person may get his or her information or what distrusted source he or she may not hear,
It's
it
still
uses
behind me, isn't it?
censorship to
Yeah, it
control
is.
thought.
It's just gonna keep hitting me
This is
for a while.
unlawful. The First Amendment confirms the freedom to think for ourselves. What we have
Thief.
said also shows the invalidity of other
Thief.
arguments made by the government. For the most part, relinquishing the anti-distortion rationale, the government falls back on the argument that corporate political speech can be banned in order to prevent corruption or its appearance.
Yeah, I'm
In
noticing the
Buckley,
external
the
hull
court found this
damage.
interest sufficiently important to allow limits on
I'd
contributions
like
but
to
did not
fix it,
extend that
but I
reasoning
think
to
I might get
expenditure
killed
limits.
if I do.
For 24 U.S. at 25.
I'm just gonna have to hope that it
When
survives.
Buckley examined an expenditure ban, it
Oh, it
found
is
that
not.
the
It
governmental
is not
interest in
surviving, in
preventing
fact.
corruption and the appearance of corruption was inadequate to justify the ban on independent expenditures.
They're
ID
gone?
at 45. With regard to
Oh,
large direct
it
contributions,
might be
Buckley
gone.
reasoned that
Nope,
they
is
could
it
be
just
given
coming
to
back?
secure a political quid pro quo ID at 26, and that the scope of such pernicious practices can never be reliably ascertained ID at 27. The
Wow.
practices
I'm getting
Buckley noted would be
murdered
covered by
right
bribery
now.
laws, see e.g. 18 U.S.C. Section 201, if a quid pro quo arrangement were proved. See Buckley, Supra, at 27, and N 28, citing Buckley versus Valeo, 519 F, 2D 821, 839 to 840, and
This
NN.
is not, this is
36 to
not
38,
going bueno.
CADC 1975, N Bank, per curiam. The court, in consequence, has noted that restrictions on direct contributions are preventative, because few if any contributions to candidates will involve quid pro quo arrangements. MCFL 479 US at 260, MPAC 470 US at 500, Federal Election Com NV National Right to Work Com 459 US
Starting to think this is like its
197,
spawn area, and I
210,
am now stuck.
1982, NRWC. The Buckley Court, nevertheless, sustained limits on direct contributions in order to ensure against the reality or
Let's
appearance
go.
of COR.
Go.
Ruption. That case did not extend this rationale to independent expenditures, and the court does not do so here. The absence of pre-arrangement and coordination of an expenditure with the candidate or his agent not only undermines the value of the expenditure to the candidate, but also alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate. Buckley, 424 US, at 47, CIBID, independent expenditures have a substantially diminished potential for abuse. Limits on independent expenditures, such as Section
I need to get out of
441B,
here before
have a
this thing
chilling
kills me.
effect extending well beyond the government's interest in preventing quid pro quo corruption. The anti-corruption interest is not sufficient to displace the speech here in question. Indeed, 26 states do not restrict independent
Whoa,
expenditures
scary.
by
Get out of here.
for-profit corporations. The government does not claim that these expenditures have corrupted the political process in those states. See Supper Brief for Appellee 18, N3, Supper Brief for Chamber of Commerce of the
I
United
just
States
don't
of
think this document was
Citizens
able to
United v.
remember
Federal Election COMMN.
or understand what was to come.
Opinion of the court.
Oh my
America
god,
as
it
Amicus
immediately hit
Curiae
my
8 to
damn
9,
thing again. I'm getting
N5.
out of here. This sucks.
A single footnote in Belotti purported to leave open the possibility that corporate independent expenditures could be shown to cause corruption. 435 US at 788
Let's get out of here. This
26.
sucks.
For the reasons explained above, we now conclude that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. Dicta in Belotti's footnote suggested that a corporation's right to speak on issues of general public interest implies no comparable right in the quite different context of participation in a political campaign for election to public office. Ibid is citing the portion of Buckley that invalidated the federal independent expenditure ban, 424 U.S. at 46, and a law review student comment. Belotti surmised that Congress might well be able to demonstrate the existence of a danger of real or apparent corruption
Can you
in
leave me
independent
alone?
expenditures by corporations to influence candidate elections. 435 U.S. at 788 N 26.
I'm at the edge of the map. I don't know
Buckley,
what I'm doing
however,
anymore.
struck down a ban on independent expenditures to support candidates that covered corporations, 424 U.S. at 23, 39, N 45, and explained that the distinction between discussion of issues in candidates and advocacy of election or defeat of candidates may often dissolve in
Well, where did
practical
you come
application,
from, bro?
ID at 42.
Leave me alone.
Belotti's dictum is thus supported only by a law review student comment, which misinterpreted Buckley. See comment, The Regulation of Union Political Activity, Majority and Minority Rights and Remedies, 126 U. Piel, Rev. 386, 408, 1977, suggesting that corporations and labor unions should be held to different and more stringent standards than an individual or other associations under a regula. Tory scheme for campaign financing. Seizing on this aside in Belotti's footnote, the court in NRWC did say there is a sufficient governmental interest in insur, ing, that substantial aggregations of wealth amassed by corporations would not be used to incur
Okay, wait.
political debts from legislators who
Seizing on this aside in Belotti's footnote, the court in NRWC did say there is a sufficient governmental interest in ensuring that substantial aggregations of wealth amassed by corporations would not be used to incur political debts from legislators who are aided by the contributions. So there was at some point someone being reasonable enough to say, hey, we should not let the influence of political war chests funneled through the corporate form impact society. NRWC. NRWC? Court. National Rights Work Committee. Okay. Corporation's ability to select funds for its segregated contribution. Not violate the first. Oh god, what page are we on? Page 50. Wow, okay, so we're like a third of the way through. It is 5:02 p.m. We have been streaming for about 3 hours exactly. So that means this whole thing's going to be 9 to 12 hours. With that in mind, I think I am going to go ahead and stop here on page 50, and I will continue streaming this over the next week or so as I try to finish this document. And then I have to read about 20 other documents, not 20, probably 7 or 8 other documents that are all much shorter, 3 or 4 pages each. I'm going to go ahead and end stream here, and then I will start up again sometime. Probably not tomorrow. Maybe tomorrow. Who knows? I'm not gonna leave it up. Leave it up to fate. We'll see what happens. I'll have the weekend as well to finish reading this, so that'll be lots of extra time. Yeah. Okay. I will see you all next time as I continue reading. I'm on page 50. Gotta remember that for next time. Page 50. And then I'll keep going from there. I'm gonna save my game. Even though I'm like gonna die soon. Okay, stopping stream. Goodbye. We'll continue.